नहीं ये तो हम अगर सर बोले अगर वो बोलेंगे तो ये वो बंद कर Yes, sir. Jesus.
समझ उसका समझ हाई कोर्ट पहुंच गया। हाँ सर वो तो आप ऊपर आना है कोड नंबर 3 को सब बता दें। हाँ वो सब बता दें चैम्बर में। वाले हुए थे
Yes, right. Yes.
गुड मॉर्निंग सर। आज लाइव और आज से सर
आप भी आप कर लीजिए अपने आप साथ चलिएगा। हेलो हेलो इंक्रीज करवा देती। हेलो हेलो यस सर
अरे फोकस रहेगा यहाँ जैसे इसको चालू रखना पड़ेगा शुरू होने ऑन रहेगा सर ये तो होगा ऑफ जब
तो यहाँ से गिरने का खतरा रहेगा ना, इसको ऐसे नीचे रखे ना ज्यादा बेटर रहेगा।
तो फिक्स करवाएंगे इसको
नीचे ना सामने को
हम कुछ कराएंगे इसको ना।
हेलो हाँ तो रही आवाज हेलो आ रही है ऐसे आवाज है ना
क्या है?
वेरी नाइस। अच्छा, तो आप बिल्कुल उसमें
पूरा ऑनलाइन चल रहा है।
महाराज बड़ी जल्दी आ गया आज लाइव आएंगे सर। आज आपने जो है
क्या बस रहा है? लाइक लोग पढ़ना पड़ता है।
लाइक करो, लाइक कर रहा हूँ।
फोटो देख लीजिए आप जाए उनके साथ जैसे ऋषि ठाकुर आप परसों में कब आ गए?
सर नमस्कार सर।
23 को है।
हाँ जी
रविंद्र जी क्या भी
क्या चाहिए सर? आज से टेस्टिंग स्टार्ट है वैसे।
क्योंकि जब मर्जी आपको आने की जरूरत है, जब मर्जी चल रहे हैं।
सर ये वैसे तो डिपेंडिंग अपॉन बार की क्या बोलते हैं आप, ऐसा एक्सेप्शन नहीं है अभी। सीनियर एडवोकेट से जब स्टार्टिंग
हम तो है
तो कर रही है।
अच्छा यार हो जाए तो यार। क्यों विकी भाई चंडीगढ़ दिल्ली में जाओ ये होना चाहिए। बेसिकली बड़ा इंपॉर्टेंट है इशू ये। नहीं ब्रदर देख सकते हैं, आप कर भी सकते हैं। बेसिकली जो सुप्रीम कोर्ट की गाइडलाइंस आई थी ना, उन्होंने कहा था कि जून से आप कोशिश करो कि ऑनलाइन सारे हाई कोर्ट सारी कोर्टें ऑनलाइन करो। मर्जी है वकील की जैसे करते हैं। छोटी है सर पर
आप कर
आप कॉलेज पे जाओ ना। अभी कॉलेज के अंदर जो आता है ना हमारे जो वीसी का जो ऑप्शन है, बस वो क्लिक करो ऑटोमेटिकली अप्लाई करना चाहिए मेरे हिसाब से।
कोई भी ट्राई कर सकता है।
अब इन्हीं का रिक्वेस्ट करनी पड़ती है।
नहीं होगा सबके लिए।
अरे इतनी छोटी स्क्रीन है देखिए वाली।
हाँ
मतलब कि जो दूसरा बंदा आरू करेगा ना दिखेगा नहीं प्रॉपर इस पे। नहीं स्क्रीन बड़ी करोगे फिर इसका? नहीं ये जो ये मॉनिटर्स लिए बड़े करोगे इसको?
आप तो खुद लाइव है ना, ये चलेगा
लॉ।
अच्छा यार रोटी नमस्ते
आज लाइव आप कब लाइव आ रहे हैं?
DRT दिया था टेस्ट करने के लिए DRT भी ऑनलाइन हो गया अब है बंदे वो तो मुझे नाम लिखा सेशन दे देता है एंड यार की वो बस मुझे ये तो दाखिल में बंद करके कदम जल्दी में बोल रही है फिर की और गड्डी बोल रही है शाम में उसको डेरा देने के लिए ये भी हो गया इसमें
प्रिंस ऑफ पार्टी वाला हो गया प्रिंस ऑफ पार्टी वाला हो गया वो आप करें हो नहीं आप करें उसको कंप्लाई कर दिया क्या
सारे स्टाफ को
बेसिकली क्या है ये जो है ना ये मॉनिटर यहाँ से ही मॉनिटर कहीं और से तो ऑन करना है आपने बाकी तो ऑटोमेटिकली
लाइट चला दिया आप नहीं दिख रहे हैं आप तो नहीं दिख रहे हैं आप नहीं दिख रहे
कैमरा नहीं आया इसके ऊपर
बाकी कुछ करें ना हम तो दे ही रहे हैं
नहीं क्या फिर मेंशन करने की जरूरत खत्म है क्योंकि फिर तो था ना जैसे मान लो मैं आपको बोलना पड़ेगा इसको बोलना पड़ेगा
नहीं है तो बोलना भी देखिए क्यों इस रिव्यू है ना स्टेट अगर वो खुद ही लगे तो एक बार चले 12 मिनट फिर मैंने पूछा
ये अपना घर तक जल्दी में है ना
कैसी ये वैसे करो
मतलब छोटा भाई
एक्चुअली क्या हो रही है जब कपड़े उतरने ना देख रहे हैं पूरे हिंदुस्तान में देख रहे हैं बोले नहीं समझे हाँ ये अपनी राजभर जी फायदे नहीं मैं बोला ना तो दिखिए वो निकल नहीं सकी कोई क्या बोल रही एक दो से 4 से 6 हाँ छोटा आ रहा है भाई फाइल में निकाले इसमें कॉल कर रहे थे ना राजीव को
यस मिस्टर खजूरिया मिस्टर खजूरिया आशु Yes, please. Rajiv Kataria.
There is similar matter already decided by the Malad.
Order has to be
In order.
all these cases.
All these cases. Please, ma'am.
Notice. But who will be appearing on behalf of respondent number 2 as of today? इसमें ऐसे करना. When these cases were taken up for consideration today, या इसको ऐसे करो. Then I dispose it off without any notice to the private respondent.
Please, ma'am.
By way of this petition, the petitioner has paid for the following. Learned counsel for the petitioner submits that in the light of the adjudication made by this court in CWP number 757 of 2025, titled TAV College Managing Committee and another versus HP Industrial Tribunal cum Labor Shimla and another, dated 5/5/25. This petition be disposed of with the observation that the applications which have been preferred by the workmen, in which the interim order has been passed, which stands assailed by way of this writ petition, comma, be decided expeditiously in accordance with law by adhering to the principles of natural justice. Full stop. In the light of the request so made by the learned counsel for the petitioner, comma, as no order adverse to the interest of the private respondent is being passed, accordingly this petition is disposed of without notice to the private respondent with the direction that the main application which is pending adjudication before the learned labor court be decided by the learned labor court by adhering to the principles of natural justice along with other similar cases by 31st of July 2025. Full stop. It is reiterated that the applications shall be decided by the learned labor court without influence by the observations which are there in the order passed by it under challenge, meaning thereby that it shall not be influenced by its earlier findings returned in the course of the disposal of the application. Khajuria Sahab. Yes, please, engineer in chief.
Lordship, in similar kind of cases, my lord was pleased to grant us stay.
No, these are against labor code.
Yes, Lordship.
By so many respondents, same.
Subject to department on the last date of.
TC2A.
Yes, Lordship.
The notice for dash, that's within 2 weeks. Then this application is disposed of with the direction that in the event of the amount awarded by the learned labor court, along with interest, along with up-to-date interest being deposited by the petitioners with the registry of this court within a period of 8 weeks from today.
Grateful.
The execution of the award under challenge shall remain stay. Next. आप आ रहे हैं गणेश? अच्छा पिछले में क्या किए? प्रेजेंस लगा लेना गणेश. Yes, please. Chairman, Secretary, Jayanand.
It's my time being Vice Mr. Singh. Through this petition, I am against the order passed by Leonard. Number 1.
Let us see the order.
Could not do that. And next is P12 Lord.
Please read it.
Number 80. And whereby I was directed to
What was the reference paid by the learned labor by the appropriate government?
your reference petition was annexed P1.
Let us please come to page 79.
79.
79.
73 Lord.
So the award has been passed in favor of the workman with the direction that you shall reinstate the service of the petition.
Sir, Lordship. Lordship.
Why should the court show any interference in the order?
Lordship, because Lordship, we have initiated inquiry against respond number 2, which is at page number 53, Lordship. Sorry, 54, Lordship. Because action took place due to the rash and negligent driving of this one number 2 was driver of school van.
Okay.
Otherwise, he has also
So he did.
section 279.
The respondent was the driver of a school vehicle.
Lordship. An accident.
With an accident?
हाँ जी,
तो हुआ क्या था एक्सीडेंट?
तो 79 का मुकदमा चला सर,
Pardon?
79 का केस चला सर इसके ऊपर, और इसने एडमिट किया था।
What was the extent of injuries? बच्चों वगैरह को इंजरी?
बच्चों को कोई इंजरी नहीं सर, ये किसी जो रूट था उससे कहीं और लेके चले गया था गाड़ी को, और दैट्स द ओनली रीजन इंक्वायरी हैज बीन इनिशिएटेड अगेंस्ट हिम।
So, did you take the inquiry to its logical conclusion?
Your Lordship,
In the inquiry, he was after.
was found guilty. He was found guilty in this inquiry, Lordship, and that thereafter we.
Notice
Lordship.
Confined to respond number 2, return for dash, steps within 1 week.
Your Lordship.
Minister Khanna notice in above terms, still further orders in the execution of the award under challenge shall remain stayed.
Your Lordship.
Yes, please. Julia sir.
In this case, my number sufficient that I will not press for claim number 1. Leave number 1. I will claim for leave number 2.
See, problem is that I can't pass an order against 50 persons.
मैं तभी बोला जी, मैं प्रेयर नंबर 1 नहीं परसू करूंगा जी. I will go for prayer number 2 only, Lordship. They will direct to provide security, Lordship.
Who?
These,
So approach them.
I have approached, Lordship.
I will direct them that taking into consideration the threat perception, they will provide adequate.
I have submitted the.
So I am not the SP. SP has to take into consideration the threats.
My Lord, my representation is already there, Lordship. Please, Lordship.
I'm not negating your request. I'm simply saying that I'm delegating you to the superintendent of police. He will see the threat perception and act accordingly at your expense. At your expense.
Right.
Police will not be provided to you at my expense. It will be at your expense.
Definitely, Lordship.
इसमें लिखना by way of this petition, the petitioner has prayed for the following release. When the matter was heard on the previous date, this court was of the considered view that no mandamus in the form of a restraint order could be passed by this court in exercise of its jurisdiction under Article 226 of the Constitution against private individuals more than 45 in number, because these individuals were not the employees of the petitioners, and as the issues were such as disputed questions of fact, therefore the petitioner was advised to have recourse to the civil court. Today, Mr. Kujulia submits that the petitioner be allowed to withdraw this petition, but with an observation that as the petitioner has already approached the concerned superintendent of police to provide security to the premises of the petitioner from
It is work site, Lordship, not for.
work site of the petitioner from unruly elements, an appropriate direction in this regard be issued.
I have approached by way of P9, Lordship.
Full stop.
30th of.
The council has referred to an extra P9 appended with the petition to substantiate the factum of the petitioner having approached the superintendent. In the light of the prayer so made by the learned council without making any observation on the merits of the case, these proceedings are disposed of as withdrawn, but with the observation that the superintendent of police concerned, the SHO का करेगा. This application is to the SHO.
No, no. The Deputy Commissioner, Superintendent of Police, SDM, then SHO, Lordship.
Sorry, the superintendent of police concerned may take into consideration the threat perception to the work site of the petitioner, and in case he deems it necessary, then protection be provided to the premises of the petitioner, but at the expense of the petitioner.
One second. Withdrawal, Lordship. That may not come.
In the withdrawal, तो फिर मैं dismiss करूँगा, then I'll dismiss it. No, then I'll dismiss it. Let me be very clear.
Lordship, this SP.
You see, please appreciate. What will happen to your prayer with regard to these 45 people? You want to forego this prayer?
Lordship, my submission is that, Lordship. This SP, Lordship. he may not be influenced by that I have withdrawn it. He will not take action.
Not be influenced because अगर मैं withdrawal में लिखूंगा dispose लिखूंगा, you may lose your right of pursuing your remedy against 45 people.
That's right.
That's why I am observing it.
Easy Lordship. Easy Lordship.
Dismiss की जगह closed as withdrawn कर दूं. I have not said that dismissed as withdrawn. Medical biotech. Yes.
Grateful Lordship. Lordship, this is covered by
Dispose of it.
Easy Lordship.
Yes, please. Sanket sanction.
I have purchased a property from the respondent bank, Lordship, and they have to
Issue notice, sir.
I'm for 3.
and now the rest of the respondents are not mutating my name, and the
Notice number 1 के लिए have you given copy to someone?
the bank officials have denied.
Notice.
4.
Lord, additional advocate general accepts notice on behalf of respondents 2 to 4. Notice to number 1 return for dash tax within 1. Reply in the meeting.
Interim Lordship.
No intent. Varun Ratan.
Okay.
What is this?
The same matter.
Same matter.
The next is also same.
Interim and final reliefs are the same for you to serve them.
With regard to status quo Lordship property.
Next. And then Chaudhary Safi.
My Lord, I will accept P4. Third copy is at page 19. This revenue sent the matter of the petitioner to the forest authority for taking action.
Please go to the appropriate revenue authority. This is not the job.
No, my Lord. What is the prayer?
No, I don't know.
My Lord.
I don't know. That revenue act is staring at my face.
No, my Lord. This next P4 says that forest authority have conveyed to the revenue authority that you have sent the file, but no proper demarcation has been carried.
Approach the superior authority. This is not the job.
My Lord, since revenue authority has sent the file, but now the forest authority says that please carry the demarcation. Thereafter, we will take the action.
The demarcation.
Revenue authority will take.
No, revenue authority means principal secretary revenue.
No, my Lord. SDM.
SDM.
Concern.
So you are aggrieved by the inaction of that man. I doubt SDM.
No.
Demarcation karna.
This letter, this file was sent by the
Mr. Chaudhary, you are aggrieved by the inaction of which authority? Which officer?
My Lord, I am aggrieved with, I am before my Lord for the reason that the forest authority are saying, to the revenue authority, that
official department.
we are ready to, we will take the action against the petitioner, but till date, the revenue authority has sent the file, but no demarcation proper has been carried. I say that in terms of this communication of forest authority, this demarcation may be carried.
You want Operation Sindoor against you?
Yes.
You want to be, so I take it that you are an encroacher.
No, मैं इसीलिए तो बोल रहा हूँ कि मैं encroacher होता तो मैं जनाब के पास नहीं आता था तो मैं चुपचाप बैठे रहना था.
Approach the appropriate authority.
My Lord,
Of the High Court.
my Lord, encroachment proceeding was started by the revenue authority.
हाँ.
They sent the file to the forest authority कि मेरे आंगन में कोई पेड़ है, फलाना है, उसको काटना है अभी क्योंकि ये encroachment है. अब फॉरेस्ट अथॉरिटी बोलती है कि ठीक है जी, अगर आप ऐसा बोलते हैं हम करने के लिए तैयार हैं, परंतु आपने आज तक हमारे ऑफिशियल के सामने डिमार्केशन नहीं.
किसने कर दिया डिमार्केशन? मैं कौन सा फारसी बोलूं?
तहसीलदार ने करनी जी.
If तहसीलदार is not acting, please approach the authority superior to him. Why have you directly come to the High Court? That is what I am observing. Please exercise the divisional power.
जनाब,
superior authority.
इसमें प्रॉब्लम क्या है? जनाब, इसमें
Sir, you have withdrawn with liberty to file approach the authority otherwise I'll pass it.
जनाब, एक छोटी सी बात सुन लें. अब दो अथॉरिटियों का झगड़ा है, मैं तो बिना बात का ही पीस रहा हूँ बीच में जी. अब मैं बोलता हूँ कि ठीक है मेरे को एक्शन ले लो, आप बार बार तंग ना करो. अब
why are you not approaching the officer superior to तहसील?
जनाब, ये जो फॉरेस्ट का लेटर आया हुआ है, ये आया है एसडीएम को.
तो
सुन लो जी, अब एसडीएम साहब ने दिसंबर महीने का आया हुआ है, उन्होंने आज तक कोई एक्शन नहीं लिया. अब मेरे को बिना मतलब के ट्रबल में कि मैं एनक्रोचर हूँ, मेरे ये फलाना गिरा दे. मैं बोलता हूँ कि ठीक है, कानून के अनुसार आप कर दो.
Please approach the authority superior to SC. Why could you people bypass everything and directly come to the end? That is not appreciated.
जनाब, ऐसी दे दे डायरेक्ट.
मैंने क्यों दे दी डायरेक्ट?
कुछ तो कर दे जनाब, क्योंकि
कुछ नहीं.
अच्छा, दो अथॉरिटियों के बीच में मैं पिस रहा हूँ पूरी तरह.
That is not the issue. Issue is you people rush to the High Court ये बिना उसके नहीं ना सर, प्लीज हैव सम सैनिटी।
वैसे जनाब इसमें जैसे अब मैं तो तैयार हूं, अब फॉरेस्ट अथॉरिटी बोल रही है कि ठीक है जी ये करके दो।
After making a submission of some kind, is permitted to withdraw the petition with liberty to approach the higher authority for the alleged inaction of the SDM concerned.
Please.
Yes, please. Yes, sir.
Please, Your Lordship. Lordship, in this case, the respondent state framed a policy, Lordship, for imparting training to the multi-purpose health worker, male, Lordship. And expression of interest was called for, Lordship. The petitioner also submitted the expression of interest, Lordship, and along with that, Lordship, he has deposited the inspection fee 60,000 and 20 lakh as security, Lordship, with the respondent, Lordship. And after that, the inspection was carried out, Lordship. Inspection was in my favor, Lordship. Now, Lordship, the respondent, Lordship, they are sitting over the matter, Lordship. Inspection has been carried out. Inspection says that the recommendation is there, Lordship. Page 93, Lordship. 93, Lordship.
There is a problem in what you people are doing. You people don't understand and appreciate that education has got nothing to do with employment. Now here is a person who wants to open some kind of a course. क्या college लाना चाहते हैं?
Multi-purpose health worker.
Multi-purpose health worker. This issue stands decided by this court almost 2 decades back. I still vividly recollect that bench of Honorable the then Chief Justice, Honorable Justice V.K. Gupta. The issue was that you were not allowing the B.Ed colleges to come up on this pretext that we do not have students. And it was argued before this court that simply because a person is being imparted education, this does not, the state is under no obligation to provide that person a job. Otherwise, you will not tomorrow allow a small child to get admission in nursery class on the pretext कि नहीं हमारे पास तो नौकरी ही नहीं.
Why don't we keep it next week? I will seek instruction.
This is, you see, they examine the employment opportunity.
Yes.
Should I take it that a person who is educated in Himachal, let us say if he becomes a dentist or he becomes she becomes a nurse,
Yes.
her employment opportunities are confined to the state of Himachal only?
No.
She can be engaged anywhere in India.
Yes.
He or she can go and seek employment anywhere in the world.
Yes. Why don't we grant me a week?
आपको ना एक बहुत गलत फहमी है कि जिस आदमी को आप यहाँ पे डिग्री दे रहे हैं आप उसको नौकरी दे रहे हैं. प्लीज इस चीज को दिमाग से निकालो.
Yes.
और कुछ चीज चाहिए वो अलग चीज है.
I may be granted some time to.
तैयार हैं जी. वो तैयार हैं जी.
Why don't we grant me a week's time to have this?
He is willing to help. He is willing to help the state to come out of the financial hardship. Notice एक और 2 के लिए सरकार 3 weeks based on that.
Yes.
Immediately after the location.
Yes.
You have to take. You see, that's why मैंने पीछे भी observe किया था. This is slightly इन लोगों के साथ it's जाती है ये. When these people spend crores of rupees.
करोड़ों रुपए लगा दिए.
And when everything is in order, then you tell them कि नहीं हमने permission.
हमने permission है.
Next.
Grateful, Lordship.
Alternatively, then the state may have to compensate them.
Yes.
That is also there.
Yes, sir.
Kindly pass forward the matter, my lord. Original counsel is not.
What is the matter?
I'm not acquainted with the fact, my lord. Just intimated.
Yes. Ajit.
My lord, the execution petition, it's a P2, my lord, page number 11. Page 2, my lord, page number 11, my lord. Pardon, my lord?
What was the order part?
My lords may kindly have order was, my lords, at page number 3, my lords.
Will issue note.
But may I see page number 47 may kindly be seen, my lords. If my lords can pass the same orders, my lords.
No, your lordship, in that.
Just a minute, sir, madam, जरा मुझे तो बोलने दो.
हो ही नहीं सकती ना.
Allow him to wait his turn.
मैं पहले बोल तो दूं जी. My lords may kindly see the similar matter was issued on the same issue, my lords, has disposed of these petitions and Annexure P2, my lords. Now, my lords, we are saying since this matter was decided way back in.
Let me go through the order part.
Please, my lords, Annexure P2 may kindly see. Para number 2 is very clear, my lords.
Page 28.
Please, my lords.
28, page 49. This is the judgment जिसकी आप execution.
हाँ जी, बिल्कुल, बिल्कुल.
Please read the judgment.
Please, my lords.
Consequently, in view of the detailed discussion as well as
जी जो पेज नंबर 38 पे है जी.
Where are the directions? Directions are in 28.
Wait,
Please,
wait,
madam.
but- Yes, your lordship.
Please read the
But
text.
there are different
Read the direction.
Please, my lords.
Please read it loudly.
Question number.
Now, which part of this judgment is not being complied with by?
Whereas they are not allowing this 3% of the rebate to me since the.
Let them file this notice.
Please, my lords.
And call करेगा सुनते हैं।
Surinder is
Otherwise, page number.
Let them file a reply.
Please, please, my lords. Please.
Yes. Yes, please. Dr. Rajesh Kumar. Yes, please. Yes, Professor.
Lord, in this case, my lord, what has happened, my lord, that there was a common water chamber, my lord, which, and the water connection which leads to the house of the petitioner was 40-year-old old man.
Where was it? It was in the land of the private respondent.
That time, my lord, it was in the, my lord, because my lord, it is a common land, and below, बहुत लोगों की जी, more than 100 people. What has happened?
ऐसा ना हवा में मत मारो कि
हाँ जी
हवा नहीं बोल रही थी मैंने
sorry.
Okay, what are the facts of the case?
Facts of the case are, my lord, that my lord, department in connivance with this private respondent, without giving any notice to the petitioner, my lord, they shifted the.
What was your right to have the water chamber on that particular area?
No, I.
You see, in terms of the averments made in the writ petition, you say that the private respondent has constructed a house over there.
Please.
Why has he constructed a house?
My lord.
If it is a ridge, if the land is ridge, on which 100 people are having rights, as you just now said.
Yes,
why the private respondent will construct a house, and why will you allow him to construct a house? I take it that it is his land.
My lord, I say my submissions are, my lord, that my lord, there was a chamber, my lord. Now chamber has been shifted.
The chamber was on whose land?
My lord, it was on the land, for the sake of our argument, my lord, it is on the land of.
For the sake of the civil code.
Oh, sorry, my lord.
It is a list between two private entities.
No, lordship. My submissions are, my lord, that my lord, without informing, my lord, they shifted it, my lord, and my lord, my water connection, which was earlier it was fixed, my lord, that has now he is not allowing us to. My lord, I made some.
This is something which has happened in 23. 23. We are taking 25.
My submission, my application may kindly be seen, my lord.
Go to this civil.
I have purchased.
It is a list between you and private individual.
My lord, my submissions are, my lord, they have shifted it without informing me, my lord.
2 years हो गए हैं.
हाँ जी. And जी सारे authorities को approach किया, my lord. Finally, I have to come.
You have to go to the civil.
My lord, the FIR has also.
Sure, right.
Lord, I will be satisfied, my lord, if at this stage, my lord may direct this authority to decide my representation, my lord. Because, my lord.
Why should I direct them?
My lord, my.
In civil law.
Anji.
In civil law, if someone is arbitrarily or is forcibly thrown out of a premises, then the party has to approach the court seeking possession without establishing title.
3 years, my lord.
No, ठीक है, withdraw करना है या dismiss करना है?
My submission, my lord, kindly be taken, my lord. My lord, I am saying, my lord, may see that, my lord, I have represented them, my lord. मेरी उसके साथ लड़ाई नहीं जी, प्राइवेट रिस्पोंडेंट के साथ मेरी लड़ाई नहीं है. डिपार्टमेंट हैज
फिर मैं दोपहर को रखता हूँ, प्राइवेट रिस्पोंडेंट के साथ आओ, दोनों इकट्ठे आओ, मैं भी डायरेक्शन दूँ.
वो जी अब चैम्बर शिफ्ट होने के बाद क्या, he is not allowing me to pass put my pipe in his land. Now
why should he allow it? You आप कहीं और से ले लो, पीछे दाएं बाएं से ले लो.
वो है नहीं जी कहीं. This is what I am saying, my lord. The chamber can be shifted. My lord, I will be satisfied if my lord may kindly, my lord. If
Of the writ petition demonstrates that the allegation of the petition.
not if they may be directed to decide my representation.
You go and establish your right.
Because Milord, Milord, my connection was 40-year-old back, Milord. It was established 40-year-old back. Lordship, I want to construct somewhere, Milord, my house, Milord, and department is changing chamber from there to somewhere else, Milord. Pardon?
You have made your submission not clear. Am I allowed to dictate the order?
It's as much. Milord, representation may kindly be directed. Otherwise, my work will be done, Milord, if my Lord may kindly please.
But I will then make an observation that if the fate of the representation is not to your liking, you will approach the civil court for the redressal of it. I will not allow you to come to claim. That may be very clear.
I will myself
give and take.
I will myself will go there, Milord.
Let me be very clear. Varna tum kab ye bologe, now the representation has been again. I will not allow. Dismiss crowd. That's
it may be, Milord. Then it may come.
Is क्या लिखा आपने?
No representation, Milord. Of
हाँ कर रहा हूँ. Is that the water supply to the house of the petitioner, which was existing for the last 40 years, was unilaterally shifted, i.e., was unilaterally shifted in the month of June 2020, that is to say that the water chamber from where the water connection was there to the petitioner was disturbed without any notice to the petitioner. According to the petitioner, this was at the behest of the private respondent, who has constructed a house over the existing water pipeline of the petitioner. Having heard Mr. Parmar and having carefully perused the information, this court is of the considered view that the dispute is primarily between the petitioner and the private respondent. On a query put to the learned counsel as to the water chamber was existing on whose land, though a very clear answer was not given to the court by the learned counsel, but he candidly stated that the land was of the private. Taking into consideration the fact that it is primarily a civil dispute between two individuals, this court is not inclined to invoke its jurisdiction under Article 226 of the Constitution. At this stage, learned counsel for the petitioner submits that interest of justice would be served in case. कौन सी वाली representation है आपकी?
Lord.
The petition is disposed of in the direction that let the
Page number 18, Lordship. नहीं
ये जी एक रजिस्टर लेटर लिखा है प्रिंसिपल
इंजीनियरिंग इन चीफ
पब्लिक हेल्थ टू द गवर्नमेंट ऑफ हिमाचल प्रदेश.
With liberty to the petitioner to approach the executive engineer concerned afresh for the redress of his grievances. He submits that in case the petitioner is still not satisfied, he will approach the civil court for the redressal of his grievances, including assailing the order that may be passed by the executive engineer. In the light of the said prayer made by learned counsel for the petitioner, without making any observation on the merits of this case, this petition is disposed of with liberty to the petitioner to approach the executive engineer concerned afresh. Is so advised. And in case any such application is filed before the executive engineer, we decide the same thing as well as the private respondent. It is again clarified that this court has not made any observation merits of the case. Petitioner is further given liberty to approach the civil court in case he is not satisfied with the is not satisfied with the order that might be passed in condition of the petition. Next. Yes, sir. Also,
Please, Your Lordship. My Lord, by way of this petition, my Lords, I'm seeking, my Lords, a mercy attempt, Your Lordships, to appear in the examination of pediatrics, Your Lordships. The case of the petitioners are, Your Lordships, they are the student of the final year of MBBS course at All India, my Lords, Bilaspur, Your Lordships. They have though attained the eligible attendance in all the subjects except for pediatrics, Your Lordships, where, my Lords, the petition number 1 is short by 10 lectures. Petition number 2 is short by 14 lecture. Petition number 3 is short by 11 lecture, and petition number 4 is short by 5 lectures. My Lords, a total 128 lectures were. Hanji.
are you the only 3 students in that class?
No, my Lords.
How many students are there?
My Lords.
If others were in a position to fulfill the lecture criteria, आप कहाँ थे? आप फिल्में देख रहे थे?
My Lords, I'll come to that, my Lords. Earlier, my Lords, the petitioner number 1 and 2, my Lords, they were suspended in third year, Your Lordship, from March 2023, Your Lordships. And the, my Lords, suspension was revoked by the order of this Honorable High Court in 30th May, Your Lordships, as they could not appear in the.
When were they suspended?
My Lord, 3rd of March 2023, Your Lordships.
3rd of March 2023.
My Lords.
When was the suspension revoked?
30th of May 2023, Your Lordships.
30th of May 23.
And my Lords.
Just 1 minute.
Your Lordships.
They were at MBBS in which year?
2020, Your Lordships.
2020.
Please.
MBBS courses of how many years?
5 साल plus.
Someone who is suspended in March 23.
Please, Your Lordship.
And suspension is revoked in May 2023.
Please, Lordship.
How will this have any effect on the number of lectures a person is going to attend in a semester which will take place in the year 2024?
No, my Lords, here the pediatrics की second year से लेके आज तक total 128 lectures लगे हैं, Lordship. From pediatrics.
So shortfall is on account of this particular.
मतलब petition number 1 and 2 की not exactly यहाँ से भी 9 जाती तब भी 4 की short रहेगी. I'll be honest with the court, Your Lordships. And my Lord,
ask you to have instruction.
Please, Your Lordships.
Notice. This is for one.
For both. For both.
You are appearing for both. For both. Examination.
Thursday वाले 22nd of May, कल
जल्दी क्यों आए?
नहीं जी 8th May को हमें ये office order मिला है. They are appearing the other examination. There are 5 examinations scheduled.
What is the date today?
19th of May.
The examination is
22nd of May.
कल तक is one. Just tomorrow.
Please, Lordship.
Counsel for the respondents 1 and 2 to have instructions as to whether, as a special case, can the petitioners be allowed to participate in the examination?
मैंने आनंद संजय अब ये प्रॉब्लम ये है कि अगला एग्जाम पीडियाट्रिक्स का 1.5 साल बाद होगा. अभी दी अदर बैच. This is the problem, Lordship. Grateful, Lordship.
You see, there is one more observation I like to make. Subject to what tomorrow, the court may be willing to allow you to provisionally sit in the examination at your own risk and peril. If you succeed in the petition, very good. If you do not succeed, excellent. But ask your clients to prepare for the examination. Then allow them to participate, subject to what your instructions are. Assuming there are very serious objections with regard to their participation, then I will not pass any.
Please,
But we have to see as to what he says.
My alternate player is also की remedial classes पहले भी लगी थी 15. I have attended all that 15. Exam के बाद वो लगा लेना जी. Please.
Another thing, I take this case as the first matter tomorrow. So please have instructions by 10 a.m. tomorrow.
Please.
If any order has to be passed in favor of these students, then let it be passed well in time.
Please.
I take it up as the first case, though it will be not so reflected in the case, but it will be the first case to be taken up. So please have instructions.
Great.
And ask the authorities concerned to be sympathetic if, in case indulgence can be shown. Why to ruin the career of these people? Yes, please. Chaudhary sir.
My lord, this petitioner has taken the loan of rupees 10 lakh from the bank, and she has paid 16 lakh. And as per Annexure P2, typed copies at page 19. The petitioner moved application for OTS or one-time settlement. And you see, in terms of Annexure P5, page 34,
her application has been rejected. May I read, my lord? This,
What is the total loan amount?
now they say that remaining amount is approximately, which I have press instruction, 15 lakh.
क्या क्यों था लोन?
Unemployed थे उसमें पति थी.
When was the loan taken by you?
It was taken in the year 2000.
But why will you give an unemployed person such a big loan?
My lord, I have paid 16 lakh. For remaining, I am saying that OTS may allow. Now they have rejected my OTS by saying that at present I am working as a lecturer, and she is working in the Baba Balkar Trust as a lecturer, and she having capacity to pay this loan, as OTS has been rejected. Whereas the loan of one ex-MLA in crores has been considered for OTS.
But question is, how many litigations did you? You should please read an extra P1.
हाँ जी, ये इसी लोन में.
Question is not this. Question is, any decree has been passed against you. So after the decree has been passed against you, how will the High Court? Why should the High Court exercise its jurisdiction under Article 226 to negate a decree itself?
नहीं, मैं 16 लाख तो दे चुका हूँ जी, और हम तो ये बोल रहे हैं कि हम
से जवाब दो. No entry. Pendency of the case, pendency of the writ petition shall not come in the way of the bank to recover the amount as is due to it from the petitioner. Yes, please.
The prayer is, please, the prayer is for release of 43 lakhs, 43 lakh 64,000 towards the work done by the petitioner, my lords.
Okay, I'll issue notice to them in case the amount is admitted, then appropriate orders will be passed.
Please, my lord.
If it is not admitted here, then you will have to take recourse to the appropriate.
Please, I'm grateful.
एक के लिए एजी साहब एक के लिए 2-4 में you will accept notice for respondents to 2 to 5 hours based on dash instructions in the mail.
Grateful.
After 3 weeks we'll have it.
Please, my lord.
Answer.
What is that case where now the government has passed the decision in my favor, lordship? Lordship, may kindly have this, lordship.
कुछ
नहीं है, ये तो रिव्यू not in review of this, lordship, because the relief stand claim in it has been granted, lordship.
So okay. By way of this writ petition, the petitioner has prayed for the following thing. Learned senior counsel for the petitioner has made available for the perusal of the court a communication addressed by Secretary Panchayati Raj to the Principal Secretary of the Government of Himachal Pradesh, 24th of January 2025, which reads as follows. उसको quote करते हैं. Perusal thereof demonstrates that a decision has been taken by the Council of Ministers that the immovable assets to property of Panchayat Samiti Kandaghat shall not be transferred to Nagar Panchayat Kandaghat. आप किसको रिप्रेजेंट कर रहे हैं?
Your Lordship, I will be appearing for the Nagar Panchayat Kandaghat, and Your Lordship, my submission is that petition is not maintainable.
Just one minute. What is the
Petition is that when the this Nagar Panchayat Kandaghat newly created, there were assets lying there, lordship, which are to be distributed as per the Panchayati Raj Act, lordship, to the local self-governments.
If you are satisfied with what the government is doing, withdraw the plea.
Yes,
No, I am saying that it has been, of this it has become. Yes, it may be quoted, lordship. Yes, yes.
I agree.
Yes, yes.
So,
Panchayat.
The senior counsel for the petitioner admits that in the light of communication dated, पहले court approach is court करें for the following. The senior counsel for the petitioner submits that in light of communication dated 23rd of April 2025, addressed by Secretary Panchayati Raj to Principal Secretary UD, the petition has been rendered infructuous. In the light of The submissions were made by non-senior counsel for the petitioner. This proceeding is closed. However, it is clarified that this court has not made any observation on the merits of the case. Yes, or the necessity of communication date or the legality of the They might like to challenge it. Yes, please. Shakshi Gautam. Yes. Thanks, Paul. Has he got something now, the petitioner?
इस वाली शायद नहीं है वो बालू वाली
Because I was told that probably auctions will take place this month. So has he participated or was he not?
I have not. But मेरा हो गया.
आपको मिल गया. You got for IMFL or for?
IMFL.
You just passed it over.
May I seek indulgence? Can it be taken up tomorrow? मैं specs भूल गया. Specs भूल गया.
Just wait for 5 days. Let us see whether your specs are required or not. Just wait for 5 days. Yes, please. For presence of parties are present. Petitioner is present. Yes, sir.
Lordship.
Yes.
You both are real brother and I dispute regarding the path number. This one court has directed the parties not to close the path of each other, Lordship, and to comply with the order passed by this one court in the same claim. Earlier also, Lordship, the contempt petition was filed. Then he admitted that he will not obstruct. Now again, he has been throwing his scooty and blocking the gate. Partition हो गया जी parties का. Please, Lordship, please, Lordship. Daughter-in-law, my lord, time and again, my lord, misbehave with the respondent, my lord. Daughter-in-law.
No, that is not the problem of the court. If their daughter-in-law is misbehaving, you cannot be allowed to violate the court order. That is your personal.
That is their, my lord.
That is your personal issue.
That is their, my lord.
Only thing is, you are real brother family.
Today, my lord, gate is open for my lord.
That's not the question, but how long will it remain? It appears to be a Atari Baga border लगता है मेरे को. जब दिल क्या बंद कर दिया, जब दिल क्या खोल दिया.
Obstruction ना create करें जी. 2 बार ही हो गया. Lordship, please, Lordship. Please.
Your client has to be then justified. Why should his daughter-in-law misbehave?
नहीं.
Not the father-in-law.
ऐसा नहीं. The allegations are. No, Lordship. These allegations are wrong, Lordship. Lordship may kindly see the order. Lecture C3. C3.
They are real brothers.
They are real brothers.
Let them be counseled by some senior counsel.
Please, madam. Counsel सूसाब थे जी पहले उन्होंने भी की हम भी कर रहे हैं हम कुछ झगड़ा कुछ नहीं पार्टीशन हो गया जी अब ये आउट ऑफ जस्ट
जब कोर्ट से डायरेक्शंस होगी ना मैं आपसे बात करूंगा ना आप जो भी अंदरूनी इश्यूज हैं आप रास्ता नहीं रोक सकते अगर आप रास्ता रोकेंगे तो वो कंटेम्प्ट बनेगी
मेरा रास्ता रोका ऊपर 3 मीटर मेरे को भी दिया जाए ना 3 मीटर रास्ता मेरे को भी दिया जाए मेरा रास्ता
अगर देखो आज की डेट में कोर्ट के डायरेक्शन अगर कोर्ट की डायरेक्शन को ये वायलेट कर रहे हैं तो जिस तरह ये कोर्ट आए आप भी कोर्ट आ सकते हैं लेकिन आप जिसको कहते हैं ना कि कानून को अपने हाथ में नहीं ले सकते
पिछली कोर्ट में गया हूँ
तो आप क्या करें इसका मैं तो इसलिए आपको बुलाया कि आप दोनों सगे भाई हैं ठीक है ना हम नहीं चाहते कि आप परिवार की जो चीज है कोर्ट इज नॉट इंटरेस्टेड दैट जिसको कहते हैं ना कि वॉश द डर्टी लिनन
हां ठीक है
दैट इज व्हाट वी डोंट वांट आप हमारे उम्र में भी बड़े हैं I take it up after some time. आप दोनों आपस इनको बैठ के बात करें
आप बात कर ठीक
आप आराम से बैठ के बताओ अगर आपके अभी भी कोई इश्यूज हैं आपस में तो simply because he is here does not mean that you will not be heard by people.
ठीक है
I take it up after some time. Next. Shri Vikas Rathod, fresh compliance not filed.
Lordship.
What is the order of last?
We have heard on the last date of hearing. My lord, since my lord, they are granting me the granting aid of SMC, my lord. Whereas the relief was regarding PTA, my lord. Right now they have. Now I will have to understand. SMC का ये it's the same section, my lord.
There is a problem.
Yes.
Problem is this: your appointment was in fact bad in law. Technically speaking, it was a bad appointment because there was no policy in vogue at the time when you were appointed. PTA policy was rescinded, SMC policy was not in vogue. However, the court has shown indulgence to you for the simple reason that rightly or wrongly they avail your services, and because they have availed your services, they cannot be allowed to take plea A or plea B to deny what legitimately you are entitled to. But because after your engagement, the policy which came into force was the SMC policy. Therefore, we can't direct them ki aap SMC.
Now, my lord, my only humble submission, lordship, that the persons, my lord, appointed after me, I have named them in my contempt petition, my lord. Only submission is, my lord. मैं क्योंकि जी लगा ही नहीं उस SMC policy में जी. And there was no SMC policy. My lord, may kindly have the judgment for a moment, my lord. My lord. My lord has discussed this, my lord.
Let us see where it has been discussed.
My lord, page 13, internal page 4 of the judgment, my lord. Para 7, my lord. It is not in dispute, not much in dispute that the petitioner indeed was appointed after a granting aid policy was resigned by the state with effect from 3/1/2008, and before the new SMC policy was introduced in the year 2012. However, the fact of the matter still remains that petitioner was appointed by the PTA. The concern.
There could not have been any PTA. You see, your appointment was made by a PTA.
That is true, my lord.
But technically speaking, there could not have been any PTA.
But
anyways, you see, basically the reason as to why the judgment was in your favor was that there used to be a PTA policy.
Yes,
Policy was decided, yet there was a PTA, Parent Teacher Association.
And
School Management Committee and PTA, कुछ नहीं था, सिर्फ nomenclature का फर्क.
इसमें my lord
Appreciate. The indulgence that has been given to you by the court is for the reason.
that spends so yes.
And the state being a model employer, it cannot be allowed to take a plea. कि जी जिसने हमारे बच्चों को पढ़ाया उसको फीस नहीं देगा, तनख्वाह नहीं देगा. You should be satisfied with
only that effect, my lord. Since my lord, my whole case is regarding the PTA. Please, lordship, my lords, may kindly have the I'll have the my lords, may kindly my lord, may kindly for a moment, my lord. There are the person, my lord, who appointed after me, my lord, and they have implemented their case, my lord, as a PTA. I have mentioned in my contempt petition, my lord. They appointed later in point of time. Let them explain that to. No, my lord. Judgments were there, my lord, of my lords. They were appointed in 2012, my lord.
the fate of your.
But my lord's observation as their lordship.
I am the best judge to.
That is between my lords. My contempt that is between contemptor and contempt, my lord. But I can, my lord, insist on this point that, my lord, I have not a single word in my petition about SMC, my lord.
There is no question.
Let us,
मैं आपकी रिट मंगाऊंगा.
हाँ जी मंगा लें, my lord.
Is it your case that I don't want it on SMC basis? Your case was very simple that I was appointed.
As PTA. I have appointed as PTA and I have not been paid a grant in it. In PTA मैंने ये लिखा है जी.
So, were you paid at SMC rates?
कब अभी जी?
या पहले?
पहले तो जो PTA ने मुझे रखा 2000 रुपए पे जी. रेजोल्यूशन पे. रेजोल्यूशन पास किया जी, उसी पे लगा हूँ जी मैं. As per there और उसमें PTA में ही था जी.
Mr. Pushpinder, One thing you have to justify.
Yes.
You can't discriminate between similarly situated persons. If persons similar to him who are appointed in the interact when there was no policy, if they have been paid granting aid as was payable under PTA policy, why to discriminate?
To that I may seek instruction, my lord, we keep it on Monday.
इसीलिए तो रखा था.
इसीलिए.
Of instructions dated 17th of May 25, perusal of which demonstrates that the granting aid that has been paid to the petitioner is on the basis of SMC policy, है ना? Then it also for the petitioner submits that as the petitioner was appointed by a PTA and as persons similarly situated to the petitioner who are appointed by PTAs after the resigning of the PTA policy, but before the SMC policy had come into vogue, have been granting aid as was being paid under the PTA policy, the petitioner is being discriminated by the respondents. So additionally, submit that he may be granted a specific instruction in this regard.
I have named in para 3, my lord. I am grateful.
Behind him?
इसी में जी कंटेम्प्ट में लिखा हो जी मैंने.
You will see. Now it is more of a luxury litigation.
I am grateful. I know that.
Google suit, yes, to
So we have complied with the order, lordship.
Yeah. Notice AG accepts notice. The court stands informed that now the order caused by the court stands complied. Proceedings closed, notice discharge. Disposed. Yes, Jivan.
Lordship, this is my contempt petition, Lordship.
What was the order?
Order was, Lordship, to decide my representation within period of no, Lordship.
My lord will dispose it off with the direction that we will take.
3 weeks. 3
Lordship.
With liberty.
Same order in next 2 minutes. Lordship.
Next 2 is the same, Lordship.
Same order.
Right, Lordship.
Yes, please. Uday Kaushik. This is a new case.
Lordship.
Legally. Notice. Notice confined to respondents 1 to 4. It will come for 1 month.
Yes, Lordship. Please, Lordship.
Executive engineer.
Yes, Lordship. Hanji, Hanji.
Editor Shimla.
Ye nahi ji.
MC Shimla. Mukul Kulkar. You are appealing for?
SJPNL Lordship. Vice Mr. Tejasvi Dogra.
SJPN के लिए आप हैं, जल शक्ति के लिए, जल शक्ति के लिए स्टेट है? Presiding is confined to respondents 1 to 4. 1 and 4 state. 3 के लिए ठाकुर साहब की प्रेजेंस रही है, 2 के लिए मुकुल की है ना? Time 4 weeks this record.
Please, Lordship. It is my petition for the release of compensation deposited with the respondent also. It is covered by the coordinate judgment passed by the coordinator.
Notice.
I'm appearing for respondent number 2, Your Lordship.
But why have you not approached Kala, sir?
I moved an application. It is covered by the judgment.
But the Kala will decide.
They have not released the amount.
I understand, but why have they not
released? Para 26, sir. Other interest total, they have moved the application. 2 more petitions have been allowed by the court.
But then we'll have to issue notice, we'll have to see the extent of this.
So far as NHI is concerned, complete deposit amount.
That I understand. If you go through the judgment passed by the Honorable Coordinate Bench, it is a judgment on merit after hearing the parties. After hearing the parties. So let us see their stand.
Kala has to determine whether they are not.
That's right.
Our role is only limited to deposition.
This judgment has attained finality.
This judgment, I do not know as to whether the judgment covers you or not.
It is covered also.
So they have a right to cry, sir. Let them cry. So you notice.
Because the award is of and other persons have already paid the amount.
दो के लिए मैम की टर्म्स था ना, तीन के लिए court stands informed that primarily the issue raised by the petitioner has to be addressed and redressed by respondent.
Please.
Learned petitioner advocate is direct to have instructions as to what is the impediment in the release of the amount which is deposited by NHI or in favor of the.
Please.
2 hafte sir, immediately after.
Please.
Next. Yes, please. Chetan Kumar. Factory. Yes, please.
We are challenging the award passed by the Labour Court Lordship. That is,
Yes, sir. What?
the termination was upheld Lordship and 50,000 at page 48, my lord. It is set a law that the punishment for misconduct must be proportionately and reasonably constituted vis-a-vis nature of misconduct proved and assumed. In petitioner's case, the termination of petitioner was slightly disproportionate punishment, my lord. When seen in the light of nature proved misconduct, the punishment imposed by the implication not only workmen but also the family member who are wholly dependent on the him for the livelihood. Thus, court have, while exercising its discretion under section 11A of the Industry Dispute Act, though uphold the order of the term, but
Termination has been upheld.
yes, my lord. But that in this lordship it was said lordship that is slightly disorderly because we are only agitating lordship before the company with respect to the death of one employee, my lord, who was washed away in a river, my lord. And
What are the grounds of challenge?
first, my lord, that the punishment is disproportionate, my lord, because we are only agitating matter, my
When
lord.
were you appointed?
In 2015, lordship. 2015 में हुए थे.
Date.
Please. अट्ठाईस 11/2015.
When were your sources?
15/9/2018.
15/9/2018. Just 1 minute. Are you very serious in assailing the award? If you go through the findings returned for issues 1 to 3, I have not very serious doubts as to whether the award of rupees 50,000 is sustainable. If the other party questioned it. There is a reference made by the appropriate government, whether your termination was good or bad in law. Learned Labour Court comes to the conclusion that the termination is good in law for the reason that it was after holding a proper inquiry. Thereafter, Learned Labour Court that you have concealed material facts from the court. You never disclosed to the court that not only you participated in the inquiry, but the inquiry was carried out in the manner in which it ought to have been carried out. Yet the Learned Labour Court, while upholding the termination, has granted 50,000 as compensation.
In this, my lord, we are only agitating with respect to death of one employee, my lord, and finding.
Notice.
Please.
Notice करते हैं. Return for tax subsidy. Records be called.
5 matters are same.
ये order.
क्या कर दें इनको?
जयदेव ठाकुर. Only thing is कि ये जो 50,000 मिले ये भी बच्चे की नहीं. Yes, please.
Vice Counsel, Lordship, I am challenging the order passed by the London Labour Court, my Lordship. Yes, my Lordship. My Lordship may kindly have the operative part, page number at 73, my Lordship.
When were you engaged?
Lordship, petitioner was engaged in the year 1997, my Lordship. 25/10/97, my Lordship. 25/10.
When was he disengaged?
My Lordship, 24/3/1999, my
When
Lordship.
did you raise the industrial dispute?
Lordship, in the year 2012, my Lordship.
Explain the delay.
My lordship, then thereafter, my lordship, the petitioner come before this honorable court, my lordship, and this honorable court has directed to refer the dispute, my lordship, to the labor court, my lordship. Then,
No, when did you come to the High Court?
lordship, I come before the High Court in the year, my lordship. 2016, my lordship.
2016,
my lordship.
Please let us see that.
First, my lordship, the petitioner has filed the claim before the learned commissioner, and the same has been rejected on the ground of delay, my lordship. Then thereafter, I come before this honorable court, my lordship, and this honorable court in the year 2016. Yes, my lordship.
The learned Labour Court has been pleased to grant you compensation to the tune of 30,000.
Yes, my lordship.
आपने कितने दिन काम किया हुआ ये बताओ?
About, my lordship, 2 years, my lordship.
ये 2 years में कितने दिन काम किया? 97 में कितने दिन किया? 98 में कितना? 99 में कितना? Because the court is not going to order your reinstatement. Let us be very clear. Only thing is as to whether the compensation awarded.
Yes, my lordship, but
Is reasonable or it is.
yes, my lordship, but the learned court, labor court clearly held that there is a violation of.
Violation, yes. That
Yes,
is like 50,000.
My lordship, there is violation of G and H, my lordship,
That is
and
like 50,000.
but it's very low, my lordship, and the rule is that where there is a violation of G and H, my lordship, then the restatement is.
Truly, yeah, now the law has changed.
Yes, my lordship. But my lordship, in the honorable Supreme Court, my lordship, may kindly have this on judgment. Grateful, my lordship.
Yes. 25F में तो now there is a discussion because honorable Supreme Court says that even after the statement.
Yes, my lordship.
Issue a notice and dispense with.
Yes, my lordship, but in this judgment, my lordship, even Supreme Court 2022, my lordship.
I know that, you are right.
Yes, my lordship. Grateful, my lordship.
DC, let them.
Grateful, my lordship.
HPSCB,
Please, my lord, I am appearing for.
accepts notice. Oh,
Yes.
Grateful, my lordship.
after record.
Grateful, my lordship.
Great.
What's your name?
You start for my lord, please.
Mahesh Thakur.
In this matter, the petitioner is seeking direction for acquisition of land, Your Lordship.
When was the land utilized?
Lordship, in road was constructed in 1986, Your Lordship. 1986 to 88, Your Lordship. Thereafter, they have passed an award partially. That is the next as annexure P2, Your Lordship, at page number 23. Kuwada land in the same Mohali, Your Lordship.
Notice. Agent of accepts notice on behalf of this one. Line 6 weeks is there. Yes. Kamlesh Verma.
Your Lordship. Lordship, I filed application under order by charge for the legally on record of the defendant number 7.
Sir, service of proposed legal representative is awaited. कोई आ रहा है? Is anyone putting in a presence? What is the matter?
Lordship, initially, government introduced a company named HVBL to supply the wholesale liquor only for in the year 2016 and 17. And various
Who is applying for defendant number 2?
What's your waiting for us to have?
आपका वकालतनामा नहीं आया अभी?
Should have 2 weeks time to file power about.
So, as per the report of the registry, power from has not been filed by defendant number 2. On the request of counsel, 2 weeks time is granted to do the next. Further, as per the report of the registry, notices to the proposed legal representatives D7A to D7C are still awaited. We have waited for 2 weeks. Just on that.
Grateful.
Yes, please. Yes, please.
Yeah, Lordship, original counsel is out of station. He's in Chandigarh, so he's not well. Lordship, original counsel is out of station, so he is not well. Lordship, actually, मतलब उनका थोड़ा सा बीमार है Lordship वो. Yes, Lordship.
काफी टाइम से देखा नहीं उनको. What's wrong with him? RK Bansal. When do you want it?
List weeks.
What's your good name?
Sunny Kumar.
Mr. Sunny Kumar, Vice Mr. R.K. Bansal. The original council is unwell and therefore the gate ordered upon you. List after 3 weeks. Shri Rajendra Singh. Yes, please.
I have already filed the affidavit, madam. In my earlier affidavit, I have mentioned in para 2 of the affidavit, madam, entire due benefit which was not released by the.
You will not file any new fresh affidavit.
No, madam. They need not to be filed, madam. We have already filed.
What is the order? Under execution, let us see the order. Let us see the order under execution.
Please, madam. This is at page, relevant page at 16.
Please read it.
In view of the above, the original application is disposed of in the term of the above mentioned judgment with the direction to respondent competent authority that the subject to the above verification on finding the application to be similar that above benefit of the said judgment, if the same have attained finality, implementation shall also be extended to him along with consequential benefit, if any, as per the law within 3 months from the date of production of the certified copy. On the basis of this, my lord, they have been passed the order. Next, my lord, that is E2.
Now the problem is that there is no per se adjudication in your case. There are no directions issued, no findings written.
Please, my lord.
Only case was if similarly situated, they will do.
Please,
They have done something. You are not satisfied with it.
Please, my lord.
Please come to the court afresh with regard to those issues which, according to you, still remain unsettled.
But, my lord, as per my affidavit, my lord, there some amount of DCRG has been released, a remaining amount not
I am
released.
not interested. Judgment does not say anything. I am here to execute the judgment.
This is
The judgment when here.
this is with all
Kindly file a fresh petition. उन specific चीज के लिए उसको तो दिला देते आप.
ये जो DCRG I have mentioned in para 2 of my affidavit, my lord, they have been 10% DCRG, remaining is pending. They are not released in the.
Sir, you should please read the judgment.
My lord.
I am here to execute the judgment.
As per the judgment, my lord, they have been released this DCRG and last date of
You don't want to.
last date of hearing, my lord, they have filed the instruction. As per the instruction, my case has been sent to the finance.
जो भी है ना सर, अब इससे ज़्यादा इंटेलिजेंस नहीं हो सकती in such like cases.
इसमें ये है जी, इसमें जो ऑर्डर पास किया है उसके मुताबिक मुझे एरिया भी मिलना है, पर टिल डेट दे हैव नॉट रिलीज द एरिया.
That is something which may be beyond the jurisdiction of this court in the light of the order.
As per the judgment, my lord, they have.
Please read the judgment. Let us read the judgment.
My lord, this is
If there is any direction, I'll have it in the.
Well, kindly this next order which was passed by the respondent on the basis of this judgment.
I'm not here to execute the orders of the authorities. I'm here to execute the order passed by the High Court.
My lord.
Read the order of the.
My lord.
क्योंकि ये ना अब ये है कि ये mixed race हो जाएगी कि इन्होंने ये दे दिया वो नहीं दिया.
Attained final.
Petition file करो. अगर नहीं दिया हुआ है, issue notice इनका reply आते whatever you are entitled to, it will be given to you.
As per the direction of my lord, my lord, they have been considered my case, and they have been.
This petition, the petitioner has prayed for the.
All consequential benefit है जिसमें जो judgment है, please kindly see this judgment part. This is statement shall be extended to him along with consequential benefits.
इसमें आपने ऐसे लिखा by way of this execution petition, the petitioner is seeking of the order passed by the learned erstwhile tribunal in OA number so dated 30th of August 2008, in which order reads as under. Learned counsel for the petitioner submits that though the grievance of the petitioner stands redressed by the respondents to a large extent, but still certain consequential benefits to which he is entitled to have not been good to the petitioner. On the other hand, the stand of the state is that the order passed by the tribunal stands complied with in letter and spirit. Whatever the petitioner was entitled to. This court is of the considered view that in the light of the order that was passed by the tribunal, as the petitioner is making a grievance that all आपके husband के थे dues?
Husband, mother.
That all to which the husband of the petitioner was entitled to. Deceased husband of the petitioner was entitled to has not been released in a favor. It would be in the interest of justice in case the petitioner filed a fresh petition highlighting those aspects of the matter so that the same could be specifically taken to their knowledge. Accordingly, these proceedings are closed by the duty to the petitioner, that is, there is still some subsisting duties. The petitioner may approach the court of fresh trial of it. Yes, please, Dhananjay. SS Pulses.
Lots of the parties are in the process of conciliation of accounts. Lots of may keep it in this side of the vacations.
The counsel for the parties submit that the parties are making an endeavor to have the matter amicably resolved.
Right.
They accordingly pray taken up on second, third.
Well,
Third, Bolo.
good.
No, I said on either second or sixth.
As my notes, please. Fifth.
List on fifth.
I'm good.
Then my justice, Shri Sambhavita.
Fresh complaints.
Rejoinder not filed.
अब fresh आनी है जी ना, the सूरजमणि.
Okay, ma'am, what is the issue?
Purchase status, Your Lordship. In the reply, they were stated that this Surajmani is pending, Your Lordship. Now it has been decided, Lordship.
Then it additional with submits that in the light of the adjudication of the case of Surajmani by the Honorable Supreme Court of India, 4 weeks time be granted to file fresh compliance.
Yes, Lordship.
After 4 weeks as prayed for, in the meanwhile, fresh compliance. Yes. Yes, Mr. Sharma.
Dr. 30th April order, Lordship, may I have? कर दिया नहीं अभी भी 30th April order.
Second April, sir.
30th 30 हाँ जी.
ठीक है सर. It serves the purpose. Learned Registered Advocate General has standard over problem received from the Superintending Engineer, 4th Circle, Shimla, HPPWD, along with which office order dated 50th of May 25 is appended. Protocol thereof demonstrates that now the services of the petitioner have been regularized. With effect from 8/2002 as a surveyor instead of waiver, subject to legal remedies as legally ordained. In the light of this judgment, these proceedings have not. In the light of this judgment, these proceedings.
इसके बेनिफिट भी देने जी अभी हैं जी, फिर वो दोबारा आना पड़ना ही फिर.
आ जाओ सर.
नहीं ये तो वो तो बेनिफिट दिए नहीं जी.
Subject to legal rights. Next, Deepala Sharma. Yes, ma'am.
Lordship, only petitioner number 1 have received 90,000. The rest of the petitioner have not received anything.
Yes, what are your instructions? Actually, what was the order passed by the court?
Notification of pay as well as the benefit of reducing their shall be given to the petitioner within 90 days. In case needful was not done, 6% interest also. Page 30.
District General over a copy of instructions received from Director Elementary Education, Director School Education क्या हुआ ये? What is the name of school education? अब नहीं रहा है? कब से? और ये भी ये
प्लस टू तक एक ही है भैया अभी।
बेटे ऊपर पढ़ो आप, EDN नंबर सो एंड सो कांगड़ा, डायरेक्टर ऑफ स्कूल एजुकेशन हिमाचल प्रदेश शिमला, ये क्यों? Has this office been shifted to कांगड़ा के क्या? अभी नहीं। इसमें ऐसे लिखना है, इसमें ऐसे लिखो। Learned additional to general apprises the code on the basis of instructions this year. That the areas of bill of she will be guessing and और किसके किए क्लियर आपको?
As far as Rajkumar student there is certain Rajkumar in के certain election अक्षय in place.
नहीं, आपने कहा कि दो के किए।
विजय सिंह और प्रेमचंद।
प्रेमचंद। Shri Vijay Singh retired OT and Shri Premchand retired TET. Now stand released indefinitely. He submits that as far as the other incumbents are concerned, more time is required by this state. On the request of learned additional list after 4 weeks, fresh compliance affidavit.
My lord, this my lord, we have already filed the reply to this tribal application, my lord.
What is the issue?
Is my lord, he was direct, he was reinstated in the service with all consequential benefits. He was working as conductor, my lord. And in his revival application, all consequential benefit has been paid, my lord. Only 20 years increment and 4 no 14. They have filed this application. So we have considered and rejected, my lord. In view of the
let him come. Let the learner come.
Please, my lord.
Mandeep Chandresh.
Please, my lord. After passing the judgment by this honorable court, my lord, again HRTC has released the area in installment, my lord. They have paid in installments, my lord.
What is the judgment?
Judgments, my lord, due and page 20, my lord, of the execution, this contempt petition, my lord. Consequently, the respondent are directed to pay the due and enhanced relief along with the area to the petitioners within a period of 6 months from today. However, it is made clear in case the same has not been paid to the petitioner within the appropriate time, then in addition due statutory benefit the petition shall be also be paid interest at the rate of 9% per annum.
You will continue to get interest. You will continue to get interest till the time they make good business.
Yes, my lord. But they have not paid the full amount, my lord.
तो interest मिलता रहेगा ना जब तक full amount नहीं मिलेगा.
But
even how much amount is remaining now? How much amount has been paid? 34. What?
34%, your lordship. We have released the amount on
in installment, my lord.
टोटल कितना पैसा रिलीज किया अभी आपने इनकी?
ये बताया नहीं जी इन्होंने. बताया.
तो पेट ने बताया होगा.
इन्होंने only 10% दिया जी, 10%.
But 10%, assuming 100 crore is payable, so 10% of that is very handsome, 10 crore rupees. और अगर 100 रुपए मिलने तो 10 का 10.
Approximately one petitioner is 1,50,000, my lord. 1 lakh. Please, my lord.
So according to you, each of the petitioners is entitled to about 10 lakh rupees.
No, my lord. They have paid only 15,000 as per post.
According to you, the total areas which may be payable to a petitioner will be approximately around 10 lakh rupees.
No, my lord. Approximately all petitioners 35-40 lakhs.
Per petitioner.
Per petitioner 1.5 lakh.
You're not understanding the value of this. What I'm asking you is that in all, a petitioner is entitled to about 10 lakh rupees. एक petitioner के कितने पैसे बन रहे हैं?
1.5 लाख रुपए.
बनना है.
हाँ जी.
उसका 10% दिया है.
10% 15,000 रुपया दे दिए.
There was no that. Then you give them 10 tickets of Volvo, Delhi, Shimla. Sorry. You see, let us take a case. That's why I was asking. Let us take a case that you owe 1 crore rupees to 30 people.
Please.
And the court may show some indulgence कि 25-20-15 लाख अभी दे दो. बाकी if you in all owe them 10 lakh rupees. तो ये तो 15,000 रुपए आप you are a lawyer. If you have to take a fee of 1 lakh rupees from your client and he gives you 10,000 rupees, उससे बनता है?
That is absolutely right.
So then absolutely pay them.
You see, but you see, our MD is out of country, Your Lordship. He will come.
On Friday, my lord has passed the order, my lord.
Has he flown out of India by occupying a seat in an aeroplane or Rassi se lada ke? Who is paying for the expenses of the MD if he is traveling outside? I am not questioning why he is going outside. Who is bearing the expenses? कितने expenses होंगे? इन लोगों के आपने लाख रुपए नहीं दिए. Retired employee.
Yes, my lord. Retired.
You see the plight of these HRTC क्या कर रहे थे ये? They were serving as what?
Different post पे जी कोई driver है, conductor है, foreman.
It is pathetic. You see the, honestly speaking, even someone like a driver or a conductor.
Please.
I don't know ये महीने में कितने दिन रास्ते पे रहते हैं क्या? Physical exertion, mental exertion, 40 बंदे की जान आपके हाथ में है. And of that day, you pay them immediately. I am passing it over. Have specific instructions. Within what period you will pay them?
It may kindly be taken after 1 week. So I will seek the appropriate instructions.
इसमें ऐसे लिखना, learned counsel for the petitioner submits that though some amount has been paid to the petitioners, but it is only a meager installment of roughly rupees 15,000 per petitioner.
Please. 15, 20,000, 25,000.
15,000, approx 15,000 per petitioner.
Please.
And
15,000 तो किसी को भी नहीं, 25
चलो 20,000 कर दो.
20, 20.
अभी भी नहीं लिखा है इन्होंने, आप बताओ और लिखना वही लिख दे. 20 to 25,000 per petitioner. And the balance is not being paid for the reasons best known to the corporation. On the request of the counsel for the corporation, the matter is listed on dash. Should you have another account?
Please.
On the said date, learned counsel for the corporation to have specific instructions as to in all what amount is payable to the petitioner.
Please.
And how soon the same shall be paid to the petitioners along with interest in terms of the judgment passed by this court on 8th of May.
Please.
My name is
Wakalatnama. Name of learned counsel will be reflected in the copy. File Wakalatnama within 1 week. Undertakes to file Wakalatnama within 2 weeks. Yes, Mr. Suhail Khan, Manish Sharma. Shri Dhik Sharma. ये कैसे?
Your Worship may take it after 4 weeks, Worship.
Okay, now senior counsel. What is the issue, sir?
Your Worship, the petitioner was not granted second time on promotion scale. When the petition was filed, they came with an order that it is released. Now, Worship, they claim that they have fixed it, but still I have not got anything. Let me have instructions, Worship, that at what stage that is.
Now senior counsel for the petitioner. Yes, we take after 4 weeks to enable him to have instructions as to whether the judgment will issue stands compliant with the law. List on dashes. ठीक है? Yes, Mr.
Yes, my lords. My lords will have the order, my lords last order of 6th of May. My lords has fixed this for arguments on my OMP 17, which is under order 39 rule 1 and 2. My lords, on the other applications that I had moved, 435, 436, 438, etc., for closing their rights, we are yet to receive a reply. My lords have been gracious enough to grant them 3 weeks time to file the replies to my applications, seeking to close the right to file written statement and replies to the miscellaneous applications. Insofar as this proceeding is concerned, more as a recap, my lords, D1, which is Karnal Food Pack Cluster, and D3.
As my learned friend has said that we have not filed reply, we have filed reply on Saturday itself to everyone, including those are on record. And with our prayer to enlarge the period for taking on record.
There is no reply to the miscellaneous applications.
All applications have been replied to. Only one application of their foreclosure, we have answered it in our application for enlargement, that their application in view of our maintainability of our application may be dismissed.
May I respectfully submit the following, my lords? what was served on us on Saturday. Sorry, my lords. Applications file, please. Excuse me, can I have some space? Thank you. This is COD, right?
When were you served?
28th of January 2025. They were served with the summons. 28, they're saying 29. My lords may take it as 29th. My records say 28th. One day here and there doesn't
matter.
30 plus 90.
Yes, my lord.
30 plus 90.
Lord. Precisely on 109th date.
Just one.
Can I have my application?
22 Friday, it was filed on 17th only.
Yes, ma'am.
It is within 120 days.
Very well, my lords. I am not on that. My lords will just permit me to present the opening submissions here. D1 and D3, Karnal Food Pack Cluster and Trade India are both ex parte. No reply filed, no written statement filed at any stage. They are proceeded ex parte.
Yes, my lord. I do vividly remember because it will entail also an argument with regard to waiver of 12A, mandatory provision of, because he would be able to make out a case.
It is on my discretion. That is the job of the court to see whether the party has made out a case.
Yes,
urgent relief.
Definitely, my lord.
For urgent relief.
That is, yes, my lord.
I am only on the following points, my lords. I'm just setting out, so to speak, the background. Defendant number 1, Karnal Food Pack Cluster, and defendant number 3, Trade India, which is an e-commerce platform, are today both ex parte.
Def 1 and 3 are ex parte.
Def 1 and Def 3 are ex parte. No written statement filed, no replies filed, no appeal filed against the order of this honorable court making them ex parte. Therefore, that's point number 1.
Contesting respondent is number 2.
Defendant 2 and defendant 4 has also served a written statement, and I'll come. I'm two ke liye.
I'm penning for 4, my lord. If we had filed the written statement.
You've already filed it.
Yes, my lord. It is at 312 page number.
No. Yes.
On 20th of April, it was served on us with a 61-day delay. No application for condemnation of delay, no setting out of any reasons as to why the delay took place. I'm only on that point, my lords. My lords will forgive me if I may seem slightly, so to speak, old-fashioned, but I believe that if there is a delay, there's an obligation on the party to at least set out on why it is a delay when it is requesting the court to exercise its discretion and condone the delay. It may well be within 120 days. My lords may only see D4, which is India Mart Intermesh, files its written statement on the 20 or serves its written statement. That aspect.
Let us say 39.1.
39.1 and 2. The only reason I'm mentioning this, my lords, is because my learned friend advises me that as of today, the written statement is actually a part of the court record. My respectful submission is.
Until and unless there is an order passed by the court, it cannot. I know.
Absolutely.
I know that.
I'm only on that point, my lords, on that limited point.
Forget as to whether the written statement is there or not.
Very well.
39.1 and 2, if their responses are there.
I'm on 39.1 and 2, my lords. Very well, my lords. Now, there is something interesting, my lords, and I'll begin with that, which will perhaps also allay, or actually not allay, cause a little graver concern. On one level, if I was to be objective and I was not involved in this litigation, it would in its own way perhaps go down to the annals of humors in court. Well, I am outside Yaros in a cab. I am preparing on my mobile. I'm checking India Mart, Zelco, Glucose. I reach the Honorable Legislative Assembly of this whole court of this state. I received 3 things. I, as a counsel for the plaintiff, 3 things. First, an SMS from India Mart saying defendant number 2 will reach out to me offering the product. Next, from defendant 2, from a mobile number which is shown up in Truecaller and is shown as Sri Zelco Foods and Mr. Sunny Chug, I get messages with screenshots, with videos of the product being manufactured under the machine. That's why I said, on one level it is high. It's actually entertaining that the plaintiff's counsel is getting messages within the territorial jurisdiction of this court. I next get an email offering me from India Mart, offering me, telling me that Mr. Sunny Chug will send this material to me. I just have to show my interest. And the reason it happens is this. I have gone on Google, I have typed Zelco Glucose D, links open up India Mart. I open the India Mart page. I click on visit. I scroll through the page. India Mart captures my mobile and my email. Their algorithm enables that. It is communicated to defendant 2, who perhaps has this, which is why AI is truly artificial. Human intelligence would have said, don't do this. Not when a case is listed that day. But their algorithm says, Turant bhejo message offering the impugned products for sale to the plaintiff's counsel. That is point number 1. Millets, we have the printouts, is not as yet part of the record. My case is this, Millets, on merits. And I'm not gainsaying, Millets will have the plaint, lest I be accused of suppression. While I'm arguing the 39(1) and 2 Millets, the plaint, perhaps I'm relying on it, because in that sense is a more comprehensive document which sets out the sequence of events. Trademarks Act.
And copyright.
Copyright Act is marginal. If I succeed on trademark infringement and passing, copyright is for the label design, label layout. If I succeed on passing, main thing will be trademarks, Millard. Infringement and passing of both. Today's actions are even better because on Saturday when we found defendant 2 on India Mart sells its products under our products, when we click on that tab and we have that printout as well, says the image shown is of their product Zelco Glucose-D.
So, but just to share with you,
Millets.
see what happens. Just take a case that you just take out your mobile and you say Taj Mumbai, Hotel Taj Mumbai. You will immediately be sent by the site to similar hotels.
I'm not,
you will not get the rate of Taj, but you will be immediately sent to.
I'm not disputing what Google does. It shows up options. I'm saying when I click on that link of India Mart, it takes me straight to Zelco. That link which says Sri Zelco Glucose-D. What we find on Saturday is that on the India Mart page, which is Sri Zelco page on India Mart, not Google, not Chrome, on India Mart, defendant 4, what we find is their image and next to that Zydus Glucon-D written. There cannot be a clearer case of passing off. I'll present the document.
Let us see the.
But before that, if I may set out the conspectus, so to speak, the background of my case, Millets. My trademarks in question. First of all, who am I? Existential question. I ask myself that every day. But in this case, the plaintiff is Zydus Wellness Products Limited. It's a healthcare company. The trademarks in question are Glucon-D and Glucon-C. If I may quickly set out the background to these trademarks, Millets. It is not Glucon-D, Glucon-C.
They are the same as glucose C or D or something.
That is exactly the point of confusion that we have been trying to avoid, Millets. We are Glucon-D and Glucon-C, and it's a considered position that Zydus has taken, plaintiff has taken in 21 suits, where we have been blessed with injunctions from various courts, that we do not have a problem if a defendant writes glucose powder with vitamin D. We do not have a problem. We have a problem with the right Glucose-D.
Trademarks are Glucon-D and
Glucon-C, those are the word marks. We also have a bunch of label marks. My lords may come to
page 5.
Lord, page 5 is the comparison of my product with their product, where I have set out my trademarks is in paragraph 32 on page 24.
Yes.
My lords, has the registered trademarks there, which I've listed out, which I'm asserting. The earliest registration goes back to 1975. My lords, there's a full list of trademarks which we've annexed to the plaint. My lords may come then perhaps to page 31, which sets out the change in packaging over the years. My lords, I apologize, my lords, on row number 10 on page 25, my lords will see the packaging which is registered. And on 26, this is the Nimbu Pani flavor. And the next one is the Mango Punch flavor. On page 27, where my applications are pending in class 5, etc., that is for the regular flavor and the tangy orange flavor. Now, my lords, for the convenience of the scope, what we have done on pages 31 and 32 is we have set out the packaging. My lords is aware, all products, particularly consumables like this, there are minor changes over time depending on perception on what would appeal to the consumer. My lords will see 1980, what was the packaging? There is a happy family. A father, a mother, and a child wearing a Superman, I won't say Superman, but a super character uniform. The next image of 2000, that continues till 2009. 2009, we have another image of a happy family, which has the son riding on the shoulders of the father and the mother looking with admiration, affection, love on both of them, at least at the child. That carries on till 2011 and even 2014. 2014, what we introduce are 3 ribbons at the bottom. My lords, you can see that. In the second row in the table, my lords will see a yellow, a red and a blue ribbon at the bottom, a stylized ribbon. And on the left hand side, it will be on my lord's right hand side, is the left of the pack, but on my lord's right hand side, one will see a yellow bar on the side of the package. It's a double-headed arrow with the words instant energy and a battery image. The whole objective, my lords, is aware, glucose powder. It is supposed to give energy to athletes and young children, make them re-energize. I'm not on whether it works or not. Then that will make me get into my cynical self. But that was the objective of this. And that yellow band continues from 2014, 2018, 2022 onwards. The change is this time, the lad is still sitting on the shoulders of the father, but the father and the mother are looking front and all of them have beaming happy faces. In essence, this is called the happy family. This is the essential, one of the essentials of label packaging and a label trademark, registered or otherwise. So essentially what we have is...
I was just wondering why my wife never purchases Glucon-D.
My lords.
Oh God, sir. Only happy families.
I only say this, my lords. As an IP lawyer, there are times I'm compelled to make statement, but there is the other part of me which is a consumer, which is, if I may borrow the words of Miss Sonakshi Sinha from Son of Sardar, chal jhutte, which is what I feel for every advertisement. That apart, on the lighter note apart, this has been the image that we have conveyed since 1980, and this is the available material with me, that there is a happy family, that my product provides energy, typical target audience, children who play, for months, athletes who need rehydration. If I'm also at the amulets, my house occasionally used to buy this because I used to play hockey in school. The problem was we never waited, didn't have the patience as a child to mix it in water. We would just pick up the spoon and eat it. That apart. So, my lords, what we've also started doing, there are minor changes in the packaging, but consistently, my lords will see there's a white triangle, a white geometrical figure on the top of the pack with Glucon-D written in it in a trademark style. Instant energy below that, instant energy in the yellow bar side, and this image of a happy family and the use of 4 colors. Green for regular, orange for orange, a kind of a saffronish color for mango, and a yellow color for Nimbu Pani. Millers, to come to the meat of the matter, there was these trademarks, Glucon-D and Glucon-C, were originally coined by a company called Glaxo in 1930s, 1940s. Applied for, they were selling the products here when the British were ruling us. From Glaxo, the marks, label, all that, all the intellectual property rights, including copyrights, were assigned to Heinz Italia. Heinz Italia, if I may take the liberty of coining a very bad pun, we're trying to catch up with Glaxo. Heinz Italia assigned to Heinz India. Because Heinz India was a sister company or a subsidiary of Heinz India, Heinz Italia. There was a set of transformations within the company. Heinz India acquired the entire intellectual property right. In 2019, Zydus Wellness acquired the entire Glucon-D, Glucon-C, Complan, Ever, Nycil. These portfolios with their attendant goodwill reputation were acquired as part of the business itself. It's not that I just acquired the trademarks. I took over the Heinz Wellness product segment in India. My sales figures, my lords, will see is provided. It's up. I'm coming to it, my lords. My sales figures will see, my lords, and revenue expenditure till December 22 at least we have provided in tabular form. It's supported also by chartered account certificates, which is an annexure R, and this is in lakhs.
Let us see the infringement.
Coming to the infringement, my lords, the first evidence we have given is on page 5. If I may give the background here, in April 2023, another law firm acting for Zydus Wellness sent a cease and desist notice to defendant 2 or defendant 1. In May 2023, yet another law firm engaged by Zydus. Large companies have multiple law firms. The second law firm, having no knowledge of the first one, sent yet another cease and desist notice. It's all in annexure X to both defendant 1 and 2 as a single cease and desist notice, to which a reply comes somewhere around May or June or July of 2023. I am not running away from the fact that from June 23 till April 24, no action was taken. Yes, certain calls were made, reminders were made, please stop using glucose-D, glucose-C and the happy family image. No response, nothing happened. In April 2024, my officers were tasked with, so to speak, starting a campaign because of continuous commercial losses in various markets and complaints being received of products not being up to the mark. We started sending cease and desist notices. My lords, the history is given in paragraph 9 on page 10. So, my lords, page 10, 11, and 12. So, this is the background. Point F, my lords. Defendant numbers 1 and 2 and 28th July 23 saying, no, these are our trademarks. We are using it. We are entitled to use it. Products were not available. For whatever reason, we couldn't locate the products. No action was taken. We came across these products in the first quarter or towards the beginning of the second quarter of 2024. My office sent a cease and desist notice to defendant number 1 on 29th May and 1st of June. We sent a reminder on 11th of June and again on 12th of July of 2024. It was again served on 18th July. Now this defendant number 1 sends me an undertaking on 19th July 2024, agreeing to refrain from infringing plaintiff's trademarks Glucon-D and Glucon-C and associated trade recs. This, my lords, if I may seek my lords' indulgence, this would be annexure X at page 734, which is the entire compilation my pagination begins at 734, annexure X. We are deeply conscious that this is a commercial suit and there's a need for transparency. So the entire correspondence from 23 till date has been provided here. My lords, has page 734 annexure X.
Yes.
My lords, 734 is the April 28, 2023 notice sent to defendant number 2. Then 752 is a notice, common notice sent on 18th May 23 to both defendants 1 and 2, though the order is reversed in the notice. This was on 18th May, to which there is a reply on 28th July 2 months later. My lords, that's at page 776. My lords, I'm only pointing out two things because this defense has been taken, a different defense has been taken in the reply to my cease and desist. Paragraph 3, we state, my lords, this would be 777. My lord says para 3 on page 777. We state that my client, I assume that it would be both defendants, during the course of business, name and the logo as glucose-D, glucose-C. So first and foremost here, and this is sent through a counsel on lawyer's advice, considered, there is an admission here by defendants 1 and 2 that glucose-D and glucose-C is being used as a trademark, in a trademark sense. And that carries on to para 4, para 5, and through this reply. If I may take my lord straight away to page 794, which is my cease and desist notice to defendant 2, who's contesting it today, dated 18th April. May I respectfully submit, my lords, no reply was received till I think July or thereabouts. Thereafter is correspondence to defendant number 1. My lords, will come to page 854.
See, let us see. First of all,
The infringement.
the infringement per se.
Very well, my lords. The reason I was coming to that next after showing this undertaking.
If the court prima facie conclusion, then the court will ask you as to why not 12 days. If you are able to satisfy, then we'll proceed further and ask Mr. If you are not able to cross that hurdle at this stage, so court is not interested in all this at this stage.
The reason and this is building up to my argument on the submissions on urgent relief.
That is exactly what I'm pointing out.
So the timelines, my lords, become a little critical. My lords will permit me to differ.
There is no straight jacket formula as far as
There is, my lords, on a 12-way, my lords. Because, my lords, the Supreme Court, even as of I think 15th of May,
it is not an issue at all.
in the Dhanbad Fuels judgment,
You are able to convince that there is an infringement or passing off.
of passing or infringement.
Let us see that.
Very well, my
Let us
lords.
first see the definition.
My lords. Section 29 of the Trademarks Act. My act. My lord says section 29. This sets out various.
Shraddha, you were there in that case, trademark passing off case?
Malaj, the one with Dabur?
Dabur and Nihar Amla.
Yes, Malaj. Yes, Malaj.
Please give the number of that case. I just want to have a look at the order.
I'll do that. Malaj. I'll just send it.
Yes, sir. Yes, sir.
Section 29 means this sets out various categories of infringement. My lords is aware of that. We are relying on multiple provisions because there is separate infringement under each of these provisions. 29(1), a registered trademark may be infringed by a person who, not being a registered proprietor or a person using by way of permitted use. In the present case, they are not a registered proprietor of glucose-D or glucose-C, nor are they using by way of permitted use. Uses in the course of trade, a mark which is identical with or deceptively similar to. Minutes.
Sir, let's do one thing.
Very well, Millets.
I'll hear you after lunch.
Very well, Millets.
Let me just lost my list and thereafter rather than.
It'll also give me time to collect my thoughts so that I'm more focused instead of going.
In the meanwhile, I'll have that judgment also. That was
Malaj, there'll be commercial suit 15 of 22, Malaj.
15 of 22.
I'll just provide you with the judgment.
We'll have a printout.
Yeah.
Take it up at least.
Lord, there was the Venco, which your lordship had decided and upheld by the division bench on the exemption of 12A.
No, I know that.
Up till Supreme Court.
I know that.
and relegated to the mediations.
Let's only add on, it's not an adversarial position. So what has happened on Novenco is that while the Honorable Supreme Court has sent the parties to mediation, the question has been left open as to whether the suit should be dismissed or kept in abeyance.
You said so on the last date also.
That was the position. But what has happened is on 15th of May, there's a judgment in Dhanbad Fuels where the Honorable Supreme Court says, partial automation, yes, 12A is mandatory. This is not as part of the scheme. Yamini Manor is also good law. One has to assess on there's no straitjacket formula. One has to see whether I'm able to make out a case in my plaintiff pleading.
In fact, according to me, a reading of these two judgments of the Honorable Supreme Court,
Yes,
onus is cast upon the court itself.
Absolutely.
Onus is cast upon the court itself.
Easily.
It has to scrutinize
precisely.
as to whether there really is an urgency or in the garb of 12A.
Yes.
Is it moonshine that I'm spreading to prevent a business?
Or in the garb of that 39(1) and 2. Someone wants to bypass 12.
Yes. So, what request then is essentially what the Supreme Court says in Dhanbad to one extent. My reading of the judgment, we've got copies, is that there must be a holistic approach to the whole case. Where are the equities? What is the urgency?
At the same time, it is said that 12A cannot be left as a hostage to the whims of the plaintiff.
And likewise, Miller's Order 39 cannot be hostage.
Who has said so? I hope I'm not Shashi Tharoor.
Yeah, Lord, in so many words,
I know
yeah,
that.
it's there.
Don't. The court comes to the conclusion that there is no per se urgency.
Yes, Milord.
Consequences will ensue.
Yes, Milord. The conduct is to be seen. Lord. That's what.
Everything will be seen.
Yes, Milord.
Okay.
Pleasure. 2 o'clock, Miller?
2 o'clock. Yes, please.
Malad,
Puneet?
we've been recently engaged, Malad, and I've filed my attorney, Malad, but it is under some objections. Kindly grant me 4 weeks.
Attorney
we've been recently engaged by the
No problem. This is 34.
34 Malad.
इन्होंने reply file किया कि करना है?
सब कुछ हो चुका है. Everything is there.
Only hearing only.
Hearing.
Okay, Mr. Ishan Sharma.
So that it's come under the commercial courts.
Mr. Ishan Sharma, learned counsel appearing for the respondents submits that it has been now registered as an arbiter. Submits that. So more time be granted to file power of problem.
To remove objections on the power.
Submits that some time be granted to remove the objection in the power of problem. But subject to correction, I have never heard that there are objections in power of problem also.
They must have issued a attorney.
कितना time चाहिए? How much time?
4 weeks.
3 weeks. On this request, list immediately thereafter. Yes, please. Barred by 42 days. Yes.
As per the what which was available. But one legal fact which was not brought to the knowledge of this honorable court is that.
No, if the fact was not brought to the knowledge, then where is the question of review? So here.
The paragraph also page number 5 of the review petition. As per the scheme, the appeal is required to be filed within 15 days, which has been filed beyond the 15 days. And there is already a settled position by this honorable court in the division bench, which has been repeatedly followed by the honorable court. That once the appeal is being filed beyond the period of 15 days, so it is only required to be dismissed. And also the statutory authority has no time to.
No, but did you challenge it on that ground?
No.
Okay. इसमें लिखना 50-50 करते हैं. We allow your application for condonation of delay.
It is mine here.
हाँ?
It is mine.
क्या?
Condonation of.
वही करो. I'll allow it. 50% relief granted. Section 5 में लिखना in the light of the averments made in the application, the same is allowed. Delay in filing the review petition. Review में लिखना by way of this review petition. The petitioner is seeking the review of the notice करना confined to response one. By way of this review petition, the petitioner is seeking the review of the judgment passed by this court in CWP number so and so, title so and so, date 11th of October 2023, in terms whereof, the writ filed by the petitioner was dismissed and the orders passed by the appellate authorities were upheld by the court. Learned counsel for the petitioner submits that the review is being sought on the ground that this fact was not brought to the notice of this court, that the initial appeal filed by the private respondent against the selection of the petitioner was time barred. This court is of the considered view that review of a judgment can be sought only if there is an error apparent on the face of it, and when there is an admission on the part of the petitioner that review is being sought on a ground which was neither agitated nor urged before this court, this court sees no reason to recall its judgment, as review cannot be used as a tool to introduce new grounds to agitate the issue. Therefore, if this court does not find any error apparent on the face of the report petition, review petition is dismissed. Next. आपको एक से चार के लिए next case just wait. Yes, state barred by 1 year 52 days. Who is appearing for the other side? The notice review petition. What is the why review के ground के? इसको लिखना Okay, I'll keep it next week. The 8 साल का delay, you have to explain it on the request of learned AG. Just on 17th of June, as he submits that he needs some more time to assist the court. Yes, please. Pranshul Sharma. Yes, please. No, you see, Bello mein there is no time. Let us please go through the status report. Let us see. जिसकी मैंने लर्नड काउंसिल अपनी शादी है उनकी अपनी शादी है. Okay, status report filed, order to be taken on record. A request has been made. What's your good name? Mr. Pravinder Thakur, Vice. 3 काउंसिल है. अविनाश शर्मा, विजय शर्मा, वो कहाँ है? डांस करने के हैं साथ में? हैं? क्या लिखा है? Vice Mr. Pranshul Sharma submits that as the marriage of Mr. Pranshul Sharma is being formalized through. He has paid for an adjournment. List on dash. Fresh status report need not be filed, and investigating officer need not remain present on the next day. Mr. Bhushan. After? नहीं last opportunity. कब से आप time मांग रहे हैं इसमें? Pardon? That's not an issue. अगले हफ्ते रखना हूँ, अगर आ गया तो ठीक है, वरना on the request to learn Monday. Clear that no further time shall be granted to Monday. comply with the previous order. No further pending. Yes, please, Shivani Priya. It's a proxy counsel. Kuldeep Singh. Yes.
Lord, in view of the latest instruction issued by the respondent, this petition is rendered infructuous when they have initiated inquiry against respondent.
Okay, learned counsel for the petitioner submits. That is now an inquiry initiated against.
Respondent number 4.
Respondent number 4. The petition has lost its effect.
Only humble lordship a time out.
I don't even know whether inquiry has been initiated. The proceedings are closed as such, with the observation that let the inquiry so initiated be taken to its logical conclusion in accordance. And by adhering to the principles of natural justice. Within a period of 3 months from now.
I'm grateful. Your Lordship, I request some time to file reply, Your Lordship.
Closed off. Next week. Shri Ajay Sharma. Shri Dashwani Kumar. Yes, please.
Yeah, please.
Yes, Mr. Sharma. Then not after lunch. After lunch, I am already occupied. Then it will go after lunch, after the holiday. Huh?
Immediately after the ensuing.
There is a stay operating against you.
No, Madam.
No, there is no
There
stay.
is no
As,
stay.
as on date, there is no stay operating.
What is the urgency?
No urgency.
Date check. It's very good. We'll take it after vacation, sir, not on this. 18th, sir. 18th. This from you. Okay, no problem. Stop this. We'll pay for this tomorrow.
I'm highly.
Yes, Shri Sarthak Mehta, election petition. No, adjournment नहीं, issues frame होने से please give the about discrepancy. Let us read the election petition and the response and frame the issue. नहीं तो उनको बोलो online do. ये थोड़ी बात होती है. Election petition है 23. This election petition is of 2023. Until date, not even. If you are not interested, then why are you pursuing the withdraw it?
And my lord will allow me to not add it. I report not. But in this petition, not it's an election. If
आप बताइए ना, have you brought the proposed issue?
I have.
आपने बनाया proposed? दो.
Not I do not. May I read it out now?
दे दो ऐसे ही. Proposed issue.
Not the proposed issues pertains to the discrepancy on part of the election commission in this matter lost.
Okay, yes.
Any part of this matter, Lord, I go to argue this issue.
Arguing here, you have to assist in just framing the issues. You go through the issue framed by your friend. Give me the.
I don't have.
You share the issues with each other. और जो आपके common issues हो मेरे को बताओ. I'll frame the issue. It is the job of the court. I'll frame the issue. In your frame. अब देखो. तो इसके बाद. Yeah, I'll give you a day's indulgence. I'll take it up tomorrow. ठीक है? I'll take it up tomorrow. आज शाम को बैठ करके. Please frame the issue. Okay? इसमें लिखना request paid for. Any adjournment paid for by learned counsel. So this tomorrow for framing. Just share the issues, proposed issues with each other. Shri KD Sood, Shri Anand Sharma. This is that case, homestay case.
Petition, Your Lordship.
We'll have it after the vacations. I don't have time today.
Lordship pleases, but no case is made out.
Anyway, that is. Every lawyer standing on that side says so.
No, but this is a condition.
Okay. Third of July. Shri R.M. Bish. Yes, Bish.
Contempt petition 315 may be taken up. Involving in that record as income.
314 or 15, sir?
15 years.
इसमें क्या हुआ सर?
In fact, this petition he has died. I have moved it.
What was the issue, sir?
Issue was in fact a non-payment of the amount, Your Lordship, which was granted by allowing the.
Yes, there is an application under order 22 rule 3. Any objection?
In fact, the other side had also in appeal, Your Lordship, they have implemented these, Your Lordship.
But अच्छा, Minister of Agriculture, Government of India. ये इनका नहीं है मेरे को लगता है.
नहीं जी, National Horticulture Board.
Who is the Learned Council of India? DSGI.
They have assigned this matter to their own also.
कौन है? Who is the Learned Council of India? उमेश कंवर. उमेश कंवर का नाम रिफलेक्ट करो. We'll wait for some time. उमेश कंवर का नाम.
Your Lordship, in this matter, I am praying for adjournment.
कॉपी मुझे दी थी जी, बट आई थिंक दे बी बेटर एडवाइस कि उसको विड्रॉ करके. Order was lordship, in fact, in pursuance to P1 is the order lordship. P1 is the judgment. In pursuance to this lordship, P2 is their implementation. जहां वो at page lordship में 16 their implementation saying कि 1 मई 2023 से deemed इनको appointment देती है. जो इन्होंने आज affidavit फाइल किया वो कह रहे कि जी no, in view of the act they have been appointed after this date lordship. So I think they be better advised कि उसको properly पढ़ लें एक बार, otherwise that is a clear cut contempt. सिर्फ इस पे जो इन्होंने एरियर वगैरह देना था जो इम्प्लीमेंटेशन, और उसमें कह रहे कि नहीं जी वो तो 12 दिसंबर 2003 के बाद की अपॉइंटमेंट है, सो वी आर नॉट इम्प्लीमेंटिंग दैट. ये वाली पढ़ना अच्छा, मुझे भी सुबह ही कॉपी दी है जी. डीम दे दी 1 मई 2023 से, देन वी आर एंटाइटल्ड फॉर एवरीथिंग. अब वो कह रहे कि बिकॉज ऑफ दैट एक्ट जी हमारी अपॉइंट P1 लॉर्डशिप सतीश कुमार के बेसिस पे होने थे जी. P2 लॉर्डशिप एंड लॉर्डशिप में काइंडली है पेज 16, जहां पे इन्होंने स्पेसिफिकली कहा है इन व्यू ऑफ द अबव फैक्ट्स एंड सर्कमस्टांसेस the case of petition is similarly situated to the petitioner of CWP number so and so Satish Kumar and so therefore the petitioners are hereby considered deemed appointed on regular basis in the pay scale of so and so with effect from 1st May 2003 लॉर्डशिप. इसके बेसिस पे हमारे को एरियर वगैरह मिलना था जी जो सतीश कुमार में है, लेकिन जो आज इन्होंने कंप्लायंस रिपोर्ट दिया उसमें कह रहे कि जी क्योंकि इनकी एक्चुअल अपॉइंटमेंट 12 दिसंबर 2003 के बाद की हुई है तो इन व्यू ऑफ एक्ट वी आर नॉट इम्प्लीमेंटिंग. नहीं contempt petition, contempt no.
Please go through the order passed by the court.
हाँ जी.
By disposing of the petition.
हाँ जी.
Now there are two without expressing any opinion.
हाँ जी.
If there is no contempt, if you are aggrieved by your action.
नहीं रिट क्यों, मैं आई एम नॉट एग्रीव्ड बाय दिस. उन्होंने दे दी मुझे, मैं तो इम्प्लीमेंटेशन के लिए बोल रहा हूँ कि जब उन्होंने दे दी टीम डेट तो उसके कॉन्सिक्वेंशियल बेनिफिट्स तो देने ही है ना जी मुझे. हाँ जी.
As the prayer is inaudible, therefore without expressing any opinion on the merit is the court of the
हाँ जी.
That the case of proceed within considering the right of appeal.
हाँ जी.
They pass an order.
हाँ जी.
There is some grievance you are having.
मेरी ग्रीवेंस है कि जब इम्प्लीमेंट करो इसको तो नहीं, फ्रेश पिटीशन में इम्प्लीमेंटेशन थोड़ी नहीं जी. लॉर्डशिप में फॉर मिनट लॉर्डशिप. अब उन्होंने कर दिया, आप लॉर्डशिप सेट की ओके इफ दे आर सिमिलर सिचुएटेड गिव देम. वो कह रहे कि हाँ जी दे आर सिमिलर सिचुएटेड कह रहे, पर वो उसका बेनिफिट देने.
Because they have taken a call, they have given you. वो जो है वो subsequent act है. That is a subsequent order.
उसके लिए पिटीशन तो नहीं लाइक है, इम्प्लीमेंटेशन के लिए पिटीशन तो नहीं लाइक है.
Sorry, you can come to the court that despite all this order having been passed, they are not given the consequence. Issue a matter of petition. Contempt.
Lordship in my then it may come lordship that petition.
By way of this petition, the petitioner alleges willful disobedience of the directions passed by this court in CW number 9061/2022, titled so and so, which was decided on 28th of October 2022. The counsel for the petition submits that after the judgment was passed by the court, the respondent authorities passed an order, Annexure C2, and despite holding that the petitioner was entitled for deemed regularization, in effect from 1/5/2003, along with consequential benefits, subject to the final outcome of the special petition mentioned therein. Till date, the consequential benefits have not been. The court of the considered rule that as the direction passed by the court on intervention. And for a consequent thereto, an office order stands passed by the authority concerned, as far as the judgment is concerned, stands compliant. In case the respondents are not, in case according to the petitioner, certain benefits to which he is entitled to are not being reduced to him by the respondent, then the petitioner was well advised to approach the board of that by Mr. Schwan faced. And then this procedure people were limited to do. Proceedings was limited to do. I thought it will direct them to their meeting.
फिर वो एग्जीक्यूशन की फॉर्म में हो जाएगी जी रिट पिटिशन में, क्योंकि लेटर एंड स्पिरिट नहीं है जी। हाँ जी
Execution and contempt are not of the exactly what they are of the
वही कह रहा हूँ ना जी, डायरेक्शन ठीक है, अगर सिमिलर सिचुएटेड है तो उनको तो लेटर एंड स्पिरिट में वो नहीं मैं मैं ये नहीं कह रहा हूँ, आई एम जस्ट फॉर माय अंडरस्टैंडिंग ओनली लॉर्डशिप।
This sometimes a view can be taken that the High Court is now rewriting the judgment. आप चार रहे हो कि रिट फाइल करो?
नहीं मैं तो कर लूंगा जी, मैं इसलिए बोला फॉर माय ओन अंडरस्टैंडिंग, क्योंकि फिर ऐसा ना ठीक है।
You are entitled to 100% agree.
हाँ जी
But not under this. Rest फाइल करो आपको मिलेगा।
ठीक है प्लीज। ये वो इलेक्शन का है।
The petitioner is elected Pradhan of Gram Panchayat Slough district Unna, my lord. And this private respondent has filed and evidence also, my lord. Order for this one. Ajay. Pradhan, my lord, Gram Panchayat. My lord, this is the election was, my lord. अब तो 4 साल हो गए एग्जैक्ट डेट my lord. So my lord, ये है जी, it starts from 16 my lord.
Yes.
This is the order passed by they filed the election petition and this was the order passed by the SDM my lord. I am the elected candidate. My lord, Anita Devi scored 792 votes. She is my lord Bandana Rani. जी जी ground and mainly on the ground that my lord the votes were mixed up my lord. Case of the this respondent was that there was a difference of 8 votes and total polled votes are 2268. I The petition has lost the election by a margin of 18 votes. The petition has alleged that the excess 8 votes have been counted in favor of respondent. There is a detailed procedure, the manner in which the result is to be declared as per rules 75, 79 of the Panchayati Raj election rule 1994. The respondent has not placed on record even any application submitted by recounting of votes to substantiate her claim. The petitioner is relying upon the 8 votes counted in excess, but it can't be ascertained if at all these 8 votes could be polled in favor of petitioner. Moreover, the petitioner or her agent never applied for recounting during the counting process. Hence, the petition appears to be merely a roving inquiry. Then, the returning officer shall count all the valid votes recorded in favor of each candidate and record the total thereof in the result sheet in Form 32 in the case of member of Gram Panchayat, Form 34 in the case of Pradhan, Form 36 in the case of member of Panchayat Samiti, and Form 38 in case of the member of Jila Parishad. All the valid votes papers are rejected. Ballot papers shall be separately bundled and kept together in a packet which shall be sealed with the seal of the returning officer and the candidate, their election agents or counting agent, if they desire to affix their seal thereon, and on packet of the name of the constituency, the date of the counting, and the brief description of its content shall be recorded. Further, the rejection of the votes done as per the following procedure: scrutiny, rejection, ballot papers. Before rejecting any ballot paper under sub-rule 1 or returning officer or such other officers authorized by him shall allow each counting agent present a reasonable opportunity to inspect the ballot paper, but shall not be allowed him to bundle it or any other ballot paper. The guidelines recounting have been detailed down, laid down in the Rule 79 of HP Panchayati Raj Election Rule 1994, recounting of votes. After such announcement has been made, candidate in his absence, his election agent or any other counting agent may apply in writing in the district election officer Panchayat or returning officer as the case may be, or any other officer authorized by him in his behalf for recount of all any of the ballot paper stating the grounds on which demands such recount, provided if no application for recount is received within the reasonable time, the result shall be declared in accordance with provision of clause 5 and 6 of the Rule 76. Yeah. That the court must come to the conclusion that in order to grant prayer of the inspection, it is necessary and imperative full justice between the parties. That the discretion conferred on the court should not be exercised in such a way so as to enable the applicant to indulge in a roving inquiry with a view. Okay. I have heard the learned counsel for both the parties and perused the record of the law court in depth. The election petition was instituted on 10 Feb 2021 and dismissed on 22nd 8/22. It has also been on record that due to clerical mistake, the date of the decision of the election petition was written mistakenly 22nd 8/22 instead of 9/9/22, and this fact was brought to the notice of the lower court by the Srimati Bandana Rani petitioner, and the response thereof the civil authorized officer under the Panchayati Raj Act 1994 by its order has recorded that the date of decision should be 9/9/22 instead of 22/8/22. After careful consideration of the entire material on
Basically, what the learned appellate authority has said
Yes.
that the order has been passed by the court authority in a slipshod. He has not scrutinized what was required to be scrutinized while deciding. What's wrong with it?
Only, my lord. In fact, as earlier I have perused the rule, my lord, there was no written, my lord, application for recounting by them, my lord. If there is no written, in fact, in it evidence, it has also come, lordship, that it is there is, my lord, my only humble lordship. Anji.
As per the statutory scheme, applies for recounting here and there. If it is better, then the thing would be different. If it is not better, then election.
In fact, margins also, my lord, they are challenging the votes only 8, my lord. Margins 18, my lord. If, my lord, my lordship.
There is no issue at all. Why are you afraid from and the please read paragraph again. If you read paragraph from the
After careful consideration, the entire
Rule 49 Act 38 provides that all covers containing fault shall be delivered by returning officer to distress returning officer. Rule 750A of
object deal with the
old duties
ballot papers.
Valid for duties shall be counted and noted in the result sheet to 20. 66 requires an account of ballot paper to be prepared in form 29. The statutory record is required to be examined for adjudication of the real matter responsibility. The AO has not appreciated this. Now, if according to you, these findings returned by the appellate authority are correct, then the petition succeeds, otherwise not. It's better that take time-bound directions to the authority. I direct the authority to decide it within 2 weeks, 3 weeks, 4 weeks.
No matter how I'm elected, so.
तो इलेक्टिव ने वैसे इलेक्शन आ रिमांड ही तो हुआ है और ऊपर से देयर वाज नो प्रोविजन फॉर सेकंड अपील इन्होंने सेकंड अपील करी डिविजनल कमिश्नर के पास इतने दिन पेंडिंग रही दे आर एंजॉयिंग ऑन द बेसिस ऑफ दैट
Only that there is no procedural lapse at all, my lord. In evidence में आया हुआ जी कि clear sheet.
The deputy commissioner has returned certain findings.
Certain findings, clear sheet.
Demonstrate that his findings are correct.
It has to be from the record.
230 है इसको डिविजनल कमिश्नर ने भी ऐसे कहा, डीसी ने भी कहा है.
And he has also passed the order after reducing the evidence and appreciating the evidence. इसने SDM ने जी. And SDM also, my lord, when rejected the. That's why I have come before my lord, my lord. Again.
देखो पहले आप ऑर्डर दो किसी के पास अगर फर्स्ट अथॉरिटी ऑर्डर है या तो बड़ा जम्बल्ड अप ऑर्डर है
ये
आपने जो उसके पैकिंग रिलीज किया
वो है नहीं जी, ठीक वो मैंने टाइप टू करके लगाया था, आपके पास तो नहीं है.
The petitioner responded contested the election as a post of Pradhan. Gram Panchayat Zone 63. The elections were held in the month of
22 में हुआ है.
22 अगस्त 22.
हाँ जी.
The election of the petitioner was obtained by the private respondent by way of an election. The election petition registered by the authorized officer, media election P1 dated 22nd of August 2022, by primarily assigning the reason that as no application for recounting of the votes was filed by the election petitioner to substantiate her claim about the violation of the this kind of counting of the votes. Therefore, as the intent of the election petitioner appears to be of merely seeking a ruling inquiry, the same was not complete. The challenge to the election by the election petitioner was primarily on the ground that 8 excess votes stood counted in favor of the elected candidate.
मैं समझ रहा हूँ at this stage.
Which adversely affected the election result. The learned authorized officer stated that the learned authorized officer said that the election petitioner could not demonstrate that all the 8 votes were polled in her favor. ये भी लिखा है ना? कहीं पे कौन सा?
प्लीज लॉर्डशिप. प्रीलिमिनरी ऑब्जेक्शन पैरा 3 में दी हुई मैंने. ऑन नंबर
was held that the election petitioner was relying upon 8 votes counted in excess, but it could not be, but it can't be asserted if all these 8 votes were indeed polled in favor of the election petitioner only. The order passed by the authorized officer was retained by the election petitioner by way of an appeal under section 5 under section 181 of the MP Panchayati Raj Act 1980. Deputy Commissioner Una, in terms of election P2 dated 17th April 2020, by way of a detailed order, announced the appeal by returning the following. I'm quoting para 5 to 7. That is relevant. Order for 5 to 7. Okay. Report demonstrates that the order passed by the appellate authority was challenged before the Divisional Commissioner by the present petitioner. And the challenge by law for appeal to section 181 within bracket Roman 2 of HP Panchayati Raj Act was also unsuccessful as the where HSBC dated 1/2020. Though Shri PP 12,000 paid for the private respondent has submitted that the second appeal filed by the petitioner otherwise is
not maintainable.
Is not in the statute.
Please.
However, the court is not running on this aspect of matter for reason. The second authority only applies the order passed by the appellate. But there is second opinion.
नहीं है जी नहीं वो पंचायती राज एक्ट में देखो
FC के लिए लिखा हुआ सरकार ने then I'll have to
नहीं है जी नहीं इट्स नॉट
देख लेते हैं
वो ये था कि अगर फर्स्ट ऑर्डर डीसी ने पास किया था देन ओनली अपील टू या फर्स्ट ऑर्डर वो हाँ जी प्लीज प्लीज इट मे बी क्लैरिफाइड देख लीजिए उसमें पूरी 181 देख लीजिए सेक्शन 181 181 appeals, please. So here the catch what is notwithstanding anything contained in this act, any person aggrieved by an order made by the authorized officer under this chapter may in the prescribed period and in the prescribed manner appeal. In case order is passed by sub-divisional officer to deputy commissioner.
And he's going to pass final.
Authorized officer के खिलाफ जो कंप्लेंट थी वो फिर पंचायत समिति वगैरह के लिए डिफरेंट अथॉरिटीज है हाँ जी
Section 181 of the Panchayati Raj Act 37. A provision of the said statutory provision demonstrates that it begins with the norm of static clause and further provides that any person agreed by an order made by the authorized officer
authorized officer 159 में है जी डिफाइन
of the act can refer and appeal in the manner prescribed.
Please.
An order passed by a sub-divisional officer is reasonable to the deputy commissioner. The authorized officer is the sub-divisional officer.
Please.
And similarly, where the authorized officer is deputy commissioner, then the order passed to the divisional commissioner. In a case where the authorized officer is divisional commissioner, the appellate authority is financial. Section 181 has to be read harmoniously with section 161 of the Panchayati Raj Act, which prescribes the officer authorized to their election. Already reference the same is also introduced later. Therefore, in the light of the statutory provisions as are contained in section 161 and 181 of the Panchayati Raj Act, it is held for further clarification that wherein the authorized officer is sub-divisional officer, therein appeal against the order passed by sub-divisional officer is maintainable before the deputy commissioner, but an order passed by the deputy commissioner in his appellate capacity cannot be thereafter assailed by invoking the provisions of section 1.
Please.
Thus, order passed connection these things. His OTOs and his health.
Please.
Now coming to the order passed by the very redacted petitioner, I have already quoted the relevant paras below. On the basis of these things and things therein, the appellate authority can say the order passed by the law. The appellate authority primarily held that Rule 49 FTA of the Panchayati Raj Election Rules 1994 provides that all covers containing poll duty ballots shall be delivered by returning officer to a return officer, and Rule 73A of Panchayati Raj Rules and Rule 73 thereof provides that counting of votes received to poll duty ballot papers are to be dealt in what mode? Learned application of the health that in terms of 73A10, valid poll duty votes shall be counted and totaled in a result sheet in form 34, and Rule 66 requires an account of ballot paper to be prepared in form 29 at the close of the poll to be kept in a separate one. Learned Appellate Authority also held that Rule 75 within bracket Roman 5 requires that final result sheet of poll votes is to be prepared in form 34, and the issue whether the prescribed procedure for counting has been followed or not cannot be ascertained without reference to these statutory documents referred to in para 6 of the order by the Appellate Authority. Thereafter, Learned Appellate Authority went on to hold that the authorized officer, that is the SPM, was required to examine the record in conformance with the rule position mentioned herein above to ascertain whether the prescribed procedure for counting of the votes was followed or not, and the same could not have been ascertained without reference to these statutory documents. It went on to further hold neither done by the EO nor appreciated by the secretary. A pointed query was put to the learned counsel to the petitioner to demonstrate that these findings returned by the learned appellate authority were perverse and contrary to the law. Learned counsel for the petitioner could not do so, but submitted that the order passed by the authorized officer was also a reason under self-scrutiny. Having carefully perused the order passed by the appellate authority, the order passed by the authorized officer as well as the appellate authority, this court will now be considered that in the light of the controversy involved in the case, it would have been appropriate for the authorized officer to have scrutinized the entire record to ascertain as to whether the counting of the votes was actually carried out in terms of the provisions prescribed in the HP Panchayati Raj Election Rules 1994. This not having been done by the authority in the authority, this court finds no reason to interfere with the order passed by the learned appellate authority, who has rightly set aside the order passed by the Therefore, as this court does not find any merit in this petition, the same is dismissed and the order passed by the
Lordship, appropriate authority may be authorized authority decide within, क्योंकि दिसंबर में तो फिर next election आ जाएंगे.
Adequate opportunity में भी काट ली. हाँ नहीं मुझे भी वहाँ मतलब अपीयर होने का मौका दिया जाए.
The appropriate authority be directed to hear and dispose of the matter without being influenced by any observation made either by this court or by the appellate authority. The learned counsel for the private disposal submit that the authorized officer be directed to superintend within a time limit.
Please.
In the light of this instruction, the mission of the learned counsel is to dispose of with the direction that now let the election petition be decided by the authorized officer within a period of 6 weeks from today.
ठीक है जी
By adhering to the principles of natural justice or already on the law.
प्लीज
The authority will not be influenced by any observation made by this court or by the appellate authority, but will do the needful in sync with the order passed by the appellate authority by taking into consideration the documents of the court as well as the statutory and the rule.
प्लीज राइट
महाराज जी बातचीत कर रहे हैं
थोड़ा टाइम दे दे जी हाँ जी बिल्कुल
In compliance with the last order, the petitioner and the respondent are present in the court. Court requested to make counsel from the petitioners to show indulgence in the matter taking into consideration that the parties were real. At this stage, the court stands informed that there is some form.
Substantial thought.
But it would be in the interest of justice in case the matter is taken up after
4 week
after 3 weeks.
3 weeks, ठीक है जी
So that in the intent of the parties can reconsider.
ठीक है
Order accordingly.
ठीक है बाकी गोल्डी तो कर लेंगे जी कंप्रोमाइज हमने कर दिया जी सेटल लिखना ही यार बुला लेंगे जी स्टेटमेंट तो कराने बुलाएंगे जी आर्टिस्ट यहाँ जो स्टेट गोल्डी तो 10,000 देने पिछले
ठीक है
Reply was waited on 13/5. Taking weeks time.
Lordship may have next matter, Lordship. These two are of similar nature, Lordship.
वो है जी
Please, in that, Your Lordship, the opportunity was closed. It was order was there.
13/5 जी हफ्ते का टाइम taking weeks time.
But why are you not filing the reply? When was the matter filed?
It was filed on that.
I'm simply adjourning it by a week. If you do the needful matter.
Please.
Please adjourn it by a week.
Please.
Find it by very good.
Please.
This time after tax.
Good, sir. There are two other matters. May I give the number so that they may be listed? Please.
Yes, Vivek?
Rejoinder also stands filed, Lordship. Lordship, this is regarding revision of the circle rates, Lordship. That it's mid-year revision has been carried out, and the please, Lordship. Lordship, I may fix it next week, Lordship, because there is a slight urgency in this matter. Because the other proceedings are arising out of. No, Lordship. No. Please.
Madam, in this they have, as per 3G56, madam, they should have filed a arbitration. But because we have filed a SLP, Your Lordship, on that. जी भी लगी भी नहीं है, but file कर दिया. Sorry, it has not been listed. But madam, this was filed in September 24, Your Lordship. But as per that section, they should have filed it. Madam,
Lordship,
the award was passed, Your Lordships, in 2022, madam. After that, madam, they have filed that the circle rates are not correct. Madam, as per section 3G56, the provisions of Arbitration Conciliation Act applies. So they should have filed a section 34 objection.
no, that those proceedings already stand filed, Your Lordship. Let it be. Will please. Grateful.
Rajesh Kumar.
Also.
In this case, Lordship, initially permission was granted by the municipal committee Kangra for laying a gate, Lordship, in favor of the petitioner. गेट हमने हटाने की वो दे दी. हाँ जी, गेट हटाने के लिए, क्योंकि लोगों की भी कंप्लेंट्स आ रही थी. रास्ता, it is a public path, you can stop it. Taking into consideration that fact, Lordship, it was removed, Lordship. Earlier, according to me, Lordship, it was wrong, Lordship. Nobody can be allowed to put a gate, Lordship, on the public path. Secondly, it was to be locked, Lordship. That is also wrong, Lordship.
Lordship, in fact, in my case, permission was granted by the concerned authority to P5 at page 33. Maybe seen P5 at page 33. आपके प्रार्थना पत्र के संदर्भ में मौका निरीक्षण करने उपरांत अगर आप नगर परिषद के रास्ते के संपर्क करके सफाई करके इसमें गेट लगाकर इसकी चाबी कार्यालय में जमा करवा दें तो इस परिषद को इसमें कोई आपत्ति ना है. Then also on the next page, what they did is on 2 count have been taken at P6. 1 कि आपने चाबी नहीं दी हमारे को. P5 जी, page 33. आपके प्रार्थना पत्र के संदर्भ में मौका निरीक्षण करने के उपरांत
अगर आप नगर परिषद के रास्ते की सफाई करके
इसमें गेट लगाकर इसकी चाबी कार्यालय में जमा करवा दें तो इस परिषद को कोई आपत्ति ना है. Now that this was done. Now why the P6 at page 34? This has been cancelled by saying that you remove that gate.
Who are you? How are you affected by it?
मैंने लगाया ना जी गेट.
आपने लगाया.
हाँ जी.
किसकी भी?
अपनी पब्लिक पार्क को आप रोड से मैं जस्ट पेज 39 फोटोग्राफ देखें. ये है जो रास्ता जो गंद पड़ा है साफ करके देन रोड में टर्न द पेज फिर मैंने एक गेट लगा दिया जी. ये सारा साफ करके गेट लगा दिया क्योंकि लोग जब खुला था नहीं लोग ये मेरा घर है जी इसके पीछे सारा गंद फैलाते ले आ गए. Now this they say that
one thing is there.
Yes.
If you see page 41 and 40. Sorry.
39 Lordship.
42 से तोड़ने आ गए जी उसको फिर.
जी जी Lordship.
Page 39 apparently there was no rule. Just see page 39. There was no rule.
बिल्कुल बंद है कुछ नहीं वहां जाता कुछ.
ये साइड में जो मटेरियल स्टैक किया ना जी ये इनका ही है जी. अभी वहां से किसी को आने जाने ना दें. नहीं जी एक जी.
क्वेश्चन ये है कि आपने इनको राइट टू राउंडली परमिट है.
हाँ जी
हाँ जी
जी.
जब सफाई करा जो गेट लगा दी तो आपको रास्ता दिखना शुरू हो.
आगे से लोगों ने ऑब्जेक्शन कर दिया.
थोड़ा सा ऑब्जेक्शन
जो आगे लोग रह रहे हैं जी जो आगे
नहीं पेज 31 देखिए. सिचुएशन का जवाब है जी.
सिचुएशन ये थी जी वहां से आ जा नहीं सकते थे.
इन्होंने इंक्रोचमेंट करना शुरू कर दी जी. इसमें इंक्रोचमेंट करना शुरू कर दी और जी हमने नगर परिषद में बोला भी था जी कि इनको
आपको ये दिखाओ अगर इनके खिलाफ कुछ है तो मैं देखता हूं.
इससे पहले भी यहाँ गेट होता था जी. P4 है वो आप तो पहले गेट होता बहुत पहले जो कि रिमूव करने की कोशिश करी थी फिर लग गया था. पर P3 देखेंगे ना एक मिनट के लिए जब ये इनकी सारी बात नहीं रहेगी एम्बुलेंस रोड कहाँ से आ गए यहाँ. P3 देखेंगे एक मिनट के लिए.
There were 2 application notices on behalf which was given by us. So
Mr. Julia,
Lordship.
The court will not allow you to go beyond what you stated in the court. आपका लास्ट टाइम में ये बड़ा सिंपल सा स्टैंड था. Yes, गेट yes. दिखाना इससे क्योंकि RS से. मैंने आपको ये बोला था नाउ आई रिकलेक्ट. मैंने आपको ये कोरिलेट कर दिया कि जो RS में लैंड इन्वॉल्व है
उसका कुछ नहीं है जी. और हमने अपनी रिट में लिखा हुआ है जी कि उनको ऑब्जेक्शन भी कोई नहीं है शकुंतला को अगर बोलने भी. ठीक है.
I will ask my officer.
I will not allow him to use it.
Yes, you
but you not neither no one will use it.
ये यूज हमें दिक्कत हो रही है की वजह से जी और फिर उसको
पहले कहां से जा रहे थे आप सर? आप सर
जनाब ये तो
Mr. Panku, you see, please see the photograph page 41. Please see the photograph.
39.
Page 39 of the page. कोई रास्ता नहीं था. मैं मानता हूँ मैंने मान लिया आपकी बात कि रास्ता इसलिए नहीं था क्योंकि इन्होंने यहाँ पे चीजें फेंकी थी गंद फेंका हुआ. ठीक है. क्योंकि आपने किसी ने कंप्लेंट फाइल की कि इन्होंने अपने एप्स और कमीशन है, कमीशन से हमारा रास्ता बंद कर दिया। ये रास्ता आपको दिखा तो पहली बार ये कागजों में
5/10/24 को तहसीलदार को एक एप्लीकेशन दी हुई है जी।
डॉक्यूमेंट दिखना शुरू हुआ ना जब गेट बोर्ड लग गया।
एक P3 मेरे रिक्वेस्ट में देखेंगे 1 मिनट के लिए कि इनका कंसर्न क्या है इसमें। P3 एट पेज 31 इसमें बीच में ना ये 29 दिस इज द रास्ता 29 इसके एक साइड मेरी जमीन है, दूसरी साइड मेरी जमीन है, एक साइड मेरी जमीन है, एंड में ये जो यहाँ खड्ड है जी उसमें जाकर खत्म हो गया है। ये जो लास्ट वाला नंबर है जी 2982 जो भी है एक खड्ड है जी।
ये लॉर्डशिप जी ये रास्ता मेन जी यही है।
ये लगा दें गेट की बात खत्म।
Lordship will do that. I will have that, Lordship. Please, Your Lordship, I will have that, Lordship. Please, Your Lordship.
My lord, only regards my 2 cases because I'm going for in the marriage, my lord. I'm punctual. जब भी रिप्लाई देना जो उसका स्टेट है वो अल्टीमेटली दोनों रिप्लाई नहीं आएंगे और इंटरिम है दोनों में इंटरिम आई वुड रिक्वेस्ट यू माल
54
ठीक है भैया।
मैडम ने कोई शादी में
नहीं अब कोई केस नहीं कोई केस करना
नंबर में देना
हेलो हेलो
इक्कीस कौन सी है उसको इसको एक मिनट आगे इसको आगे करवाओ एक्चुअल रेट छुट्टियों के बाद इसमें वो हाजिरी भी वाले डेट को क्या इसके साथ 26 जून इंस्ट्रक्शन है ना अभी आप नहीं देखा नहीं मैं जब भी होना नहीं नहीं मैं ठीक बोल रहा था आप मत देख बोला कोई बात नहीं मैं सबके साथ आप पैसे आते जाएंगे उसमें मैं नहीं मेरे समझ में आ गए। एक बात और है, अगर आपका कुछ पर्सनल हो तो मैं सबके साथ ऐसा हो, पर एक कंपनी में केस में हमारे ऐसे ऐसे काम कराएंगे नहीं कुछ नहीं आया भाई ने कहा पता ही नहीं मजाक करेंगे हाँ मैंने चुके
आप रिपोर्ट किया है सर? हाँ जी नहीं अभी आपको लंच आएगा आप तो लाइव चलाओ ना अच्छा चलो
इतना मिसी लगती थी। सर ने सर को ऑप्शन
हाँ वो हम बताएंगे।
हाँ
अभी जब वो आएंगे
सर ने फिर हाथ रखी कर दिया ना।
कौन सा चलेगा पहले? कौन सा चलेगा?
यहाँ से अच्छा हवा आ रहा था, ये हवा थोड़ा बंद हो गया। जैसे
अरे और क्यों यार
हम भी उन्हीं को ला रहे थे।
हाँ वो तो समझ गया।
ना परे दे दी उस बांग को अच्छा ठीक है नहीं नहीं बैठे yes
सर पासओवर ही चलेंगे आ जाएंगे जल्दी हाँ जी हाँ जी अनिल पहला ही है कैसे नया मैटर है एक बुक है 24 का 8 ना 24 का 8 अगर जरूरत पड़ेगी तो एक बुक 8 254 254
वो ही चलेगा मैटर तो देखते हैं हाँ हेयरिंग्स कर लेंगे
एक पास ऊपर हुआ था 26 नंबर ना सप्ली वाला।
सर वो अभी थोड़ा हेयरिंग से पहले लेंगे
हाँ मतलब अभी तो नहीं लग रहा है ना, पहले कर लूँ ना मैं 1 मिनट। कर लेता हूँ।
मुझे नहीं लग रहा है क्योंकि वो ट्रांसपोर्ट के बाद 53 जब वो 53 तक चलेगी उसके बाद जैसे वो उन्होंने बताया
I know पास ओवर इसके बाद उसके बाद पास ओवर रीडिंग का तो पता
Mr. Natraj, just give it 10 minutes.
No problem.
Yes, please.
Please, my lord. Challenge my detention, my lord, which is purely wide annexure.
Please read the release platform.
Please, my lord. The petition will kindly be allowed in detention order.
What is the issue?
Detention order may pass by respondent may quashed partially. And such order has deemed because
impugned order.
Please, my lord. Impugned order, my lord. Annexure P1 page.
Please read it.
12. My lord, whereas Mr. Anil Kumar, son of Rajkishore Pillai, Madhupura, post Usari, Chandapura, Tehsil, Usari district, Champar, Bihar. Presently building number 7, room number so and so, housing number Baddi district is accused in multiple cases under NDPS Act, wherein drug and ganja was recovered from his possession. Even after getting arrested multiple cases, he was not stopped the illicit trafficking of narcotic, which clearly manifests that he is habitual drug trafficker. And the detail of 2 FIRs are there. These are 2 FIRs against me, my lord. And the para 5, my lord, importance. I am stressing on this point, my lord. And the proposed detainee did not stop illegal activities of narcotic drugs and even after his arrest in previous case. A secret report and source report sought from the field unit of police station Baddi and security staff.
See notification powers of which have been exercised by
Act, my lord.
Where is the notification?
This is, my lord, Act. Wait.
No, it has been passed under the notification under which he has been empowered. No.
This is the order under section.
Okay, please read this text. आप इसको रो मेरे पास है अपना, है ना? Yes, please read. The relevant provision.
Section 3 of Malad, this is the notification.
Section, which section? Section 3.
3, Malad, of prevention of illicit, Malad, not NDPS.
illicit traffic and
Please, my lord. That is the other. That I have.
इसी में होगा ये.
Please, my lord. Section 3, my lord.
Section 3. Please read it.
Please, my lord. The central government or a state government or any officer of the central government not below the rank of joint secretary to the government specially empowered for the purpose of this section by that government or any officer of the state not below the rank of secretary to the government specially empowered for the purpose of this section by the government may, if satisfied with the respect of the persons including a foreigner, that with the view to preventing him from engaging in illicit trafficking in narcotic drugs and psychotropics, it is necessary so to do make an order directing that such person be detained. When any order of detention is passed by the state or by any officer empowered by state, the state government shall within 10 days forward the central government a report in respect of the order. Third, my lord, this is my lord, my stress, this I am by this, my lord. For the purpose of clause 5 of the article 22 of the constitution, a communication to a person detained in pursuance of detention order of the grounds on which the order has been made shall be made as soon as may be after the detention word, my lord, used.
कहाँ पढ़ रहे हैं आप सर?
My lord, section 3, my lord, subsection my lord, 3, my lord. For the purpose of, may I read again?
Direct them to file reply and record will also be.
Yes, my lord, because you see, as per the judgment of Supreme Court, order of
this learned on behalf of the respondents, reply stroke instructions. इसमें कब के लिए लाओगे? Friday के लिए. Friday. ठीक है? Record of the relevant record pertaining to the issuance of the impugned order. We also placed for the perusal of the court on the next day.
Please.
We'll see that.
Please.
Yes, Mr. Hempal Kalti. Yes, Pandit Rohit.
Hello, sir.
कुछ अब
ऐसा कुछ नहीं यार, relief would be of.
Then you see, rather than hearing the heck of it, because it's more of an academic.
I appreciate.
Let us close it with liberty to you to keep the issues raised therein open. In case in future the need to arises, you may agitate them, and the closure of this petition shall not come near way. ठीक है?
Please, Lord.
इस वजह से लिखना, by way of this petition, the petitioner has paid for the following release. In the light of the fact that the issue relates to the HP excise announcements for the year 2024-25, which period has expired on 31st of March 2025. This petition is closed as having lost its efficacy, but by keeping issues raised therein open, so that in case in future any such eventuality again arises, then closure of this petition shall not come in the way of the petitioner in raising these said issues again in the court.
Right.
Yes, Mr. Siglani. Yes, Mr. Siglani. Apply to the application not filed. 39. Yes, ma'am. Yes, ma'am.
Please, my lord. They have filed the application for revival of the execution, and their allegation is that the benefit of 20 years increment has not been granted. My lord, we have filed the reply and we have stated that DP has been convened and this benefit has been denied to him, my lord, because it is no on.
It has been denied. You were challenged it.
To which can be granted by rejoinder, your lordship.
They have already taken the decision.
Your lordship, I have instruction to take the time from the.
I am not giving you time. List tomorrow. Ma'am ki request for list tomorrow. Yes, please. Order 22, Rule 3.
Yes,
yes, sir. Allow कर देते हैं.
My lord, may not record my consent in this.
Why? What objection do you have?
No objection, but
in he has
also. हमने file कर रखी है application contempt bringing them.
Do you have for the heck of it? कि नो ऑब्जेक्शन, अगर जिसमें जेन्युइनली होता है मैं करता हूँ रिकॉर्ड, मैं नहीं लिखता हूँ, बट इसमें यू विल व्हाट ऑब्जेक्शन कैन यू हैव?
रिप्लाई आया था इसका करते थे।
रिप्लाई देना देते रहो।
हाँ वो दे दो।
इट इज अ सिंपल केस, इसमें लिखना आपने बाय वे ऑफ दिस एप्लीकेशन फाइल्ड अंडर ऑर्डर 22/231। डिले कितना है? एक मिनट, हाउ मच डिले इज देयर?
Death malad is on 13th of May 2024.
7-8 महीने का है वैसे भी इसमें रिट है, because the by way of this application a prayer has been made to bring on record the legal representatives of the deceased petitioner. In terms of the averment stated in the application, the sole petitioner has died during the pendency of the proceedings on 13th of May 2024. He is stated to be survived by the proposed legal representatives whose details are given in para 3 of the application. Full stop. Along with the application, comma, a copy of the legal heir certificate of the deceased is also appended. Full stop. Learned counsel appearing for the non-applicant submits that appropriate order be passed in the application subject to all just exceptions. ठीक है sir? In the full stop. Having heard the learned counsel for the non-applicant, the application is allowed as paid for. The proposed legal representatives of the deceased petitioner are hereby ordered to be included as petitioners 1 to 16.
1A to
1A किया आपने from 1A to 16.
1AF.
1A to 1F. Delay in filing the application is condoned and abatement is also ordered. This of course is subject to all justice. Application disposed of, amended no parties taken on record. What is the position otherwise now, sir?
Lordship may disconnect it because that admission, that matter, it has not come up as yet. Last week it was listed, but it has reached you, Lordship.
Yeah.
So my Lord may keep it in the first week of July. So by that.
Okay. Now list for consideration after 4 weeks.
Please.
Yes, Mamta Kumar.
My Lordship appearing as vice.
Yes, please.
My Lordship, the rejoinder has been filed and may take up for consideration.
Okay, what is the matter? What is the matter?
My Lordship, it is about the mother is aggrieved because the son is.
It's a complaint was filed in the 2016. Without line merit any applications, remedies were at their stage.
Yeah, Rampur wala. Where is the who is the learned counsel? Where is the learned counsel?
My Lordship, a short pass over.
Now, मैंने पिछले टाइम भी अपना माइंड दिया हुआ था. You see, you have to put an agony to the, you have to put an end to the agony of the mother. Kindly call the counsel. No purpose is going to be served now in keeping this. Yes, Mr. Rajesh Kumar. Yes, Rajesh.
In this case, notice was issued to respondent number 3.
Okay.
And 1 and 2 had filed a reply. I want to.
R3 served. Reply filed by 1 and 2.
I want to file a.
What is the matter?
Actually pertaining to compensation because the land of the petitioner was acquired by the respondent number.
Officer and done procedure against ex party. Reply filed by response 1 and 2. Rejoinder file करना आपने उसका. Rejoinder there to within
3 weeks.
3 weeks. Mr. Kunal Verma. Yes, please. Yes, Kunal.
Lordship, there is the application for placing on record the certain documents.
Case क्या case
Lordship, the case is with regard to the limiting chances for the ex-serviceman particular class. We are rating the particular class for limiting the chances to appear in the examination, Lordship. I have challenged the 2 rules, Lordship, in which they have decreased the.
आपने reply नहीं file किया? Reply not filed more than 4 weeks.
Application.
Application में notice accepts notice reply in 4 weeks. Yes, please. So Sanjeev Bhushan.
My Lordship.
Yes, please.
My Lordship, we submitted for the application for the ex parte. We are respondent number 3.
You are appearing for number 3?
Yes, my Lordship. So kindly.
Don't worry, just 1 minute. On the last date of hearing, respondent number 3 was proceeded against ex parte. Today, ma'am has put in appearance on behalf of the said respondent, and she prays that on her oral request, order dated 21st of April 2025, be recalled and respondent number 3 be allowed to join the proceedings. As there is no request to the prayer so made on behalf of respondent number 3, order dated 21st of April 2025 is recalled to the extent respondent number 3 was ordered to be proceeding as ex parte. He is allowed to join the proceeding. Ma'am, have you filed the wakalatnama?
Yes, my lord.
Wakalatnama de diya? What's your good name?
Afreen Kaushal.
Ma'am ki presence lagana. She submits that power of attorney, stands filed on behalf of the respondent. Yes, please. Why are the other?
What is your?
क्या है? Yes, please. बताइए.
Look, this petitioner was principal. Government this degree college Sarkar Garmila. And he appointed an inquiry officer in one of the cases.
Please fight.
But RTI was applied by this, and he has no charge of this RTI. He cannot.
But this
yes, Mr.
private respondent in that inquiry was defense assistant.
Just 1 minute. Let us read the order. I will come. The appeal title is you are Rikhi Ram. Tush Kumar. Give me the facts, two facts.
अब मैं देता हूँ. This Rikhi Ram was appointed as inquiry officer. He is principal college cadre.
Okay.
This inquiry was against one lecturer of school cadre, Ajay Kumar. So in Ajay Kumar, this private respondent was the defense assistant of Ajay Kumar. Now this defense assistant made an application seeking that a preliminary inquiry which was conducted by Deputy Director Amirpur. Copy of the same be supplied to him, my lord. And actually this Rikhi Ram should have stated there and then, because I am not this is from somewhere else you take. Whatever is there in inquiry, I have given you the record. So actually he wrote to the Director of Education, my lord, to have an actual P2, which became the bone of contention. Now from Director of Education, this petitioner was given this letter, my lord, page 19. It is in
yes, you continue.
It is in the reference of letter number so and so dated 2/12/2023 on the subject cited above, and to say that the statements of the witnesses recorded in preliminary inquiry can be provided. Now, my lord, see, the report of IO preliminary inquiry is subject to Rule 14 GIO 22B, being confidential document provided mentioned not in the article of charges. Hence, the document, i.e. statement of witnesses, can be provided by GIO number by of 2007 under Rule 14. Therefore, take action accordingly. Now, I will pause here, my lord. My lords, may I have this letter? I do not know that Director of Education, what provision he mentioned. There is nothing called as GIO by.
Let us forget that. Let us see. Where is the information filed by the private respondent? Where is the by the private respondent under right to information? वो कहाँ है?
वो इनके रिकॉर्ड में होगी।
कौन है सर? स्टेट इंफॉर्मेशन कमीशन से कौन आया?
अब वो मांग क्या?
अब वो एप्लीकेशन दिखाइए जो आरटीआई में मांगी थी। ब्लैक क्यों है? ये वाला सर इसमें? ओके। ये है आरटीआई। I am to PIO compensation. After you received this information under RTI, what did you do?
मैंने उसको रूल 14 जो है CCS रूल को दे दिया because
Ma'am, are you the original counsel? Who is the original counsel?
Vishwa Bhushan.
Huh? Call him. Call him. I am passing over the matter. ये एप्लीकेशन ही मेंटेनेबल नहीं थी.
This is what I am saying. I told him. अब वो बोलते जी
RTI को इनको
और पर अथॉरिटीज को देखो जी RTI वालों ने उन्होंने क्या क्या किया मेरे साथ. मेरे को फाइन भी लगा दिया जी. मैं कहूँ मैं आई एम अ क्वासी जुडिशियल अथॉरिटी. मैंने थोड़ी RTI को जवाब देने जी. अब तो फिर कोर्ट कल को
इंफॉर्मेशन कमिश्नर कौन है? हु इज रिप्रेजेंटिंग? मैम ये नहीं बट ये थोड़ी भी दे विल नॉट रिप्रेजेंटिंग. Who will represent him? Engage a lawyer. Your state information commissioner, we have so many things to answer.
बल्कि जो एपीलेट अथॉरिटी ने फिर ठीक लिखा था जी. उन्होंने पेज 21 पे लिखा. उन्होंने लिखा भी कि ये डायरेक्टर उनको बोला भी यू अगर उनके आईना से तुम और हो तुमने क्या इन्फॉर्मेशन देने को बोल दिया. पेज 21
तो ऐसा है जो RTI है ना, राइट टू इंफॉर्मेशन एक्ट में, इज द इंक्वायरी ऑफिसर अ PIO आल्सो? नहीं है. तो जब इंक्वायरी ऑफिसर PIO नहीं है और एक आदमी ने उसको PIO बना के इंफॉर्मेशन मांगी, तो आपको क्या इतना दिमाग में, आप लोगों को इतना नहीं पता है आपके ऑफिसर्स को कि हाउ टू डील विद दैट एप्लीकेशन और अपील?
कल को कोर्ट से बोलेंगे जी. कल को कोर्ट से बोलेंगे हम
कोर्ट मांगेंगे
राइट टू इंफॉर्मेशन में दो.
Issue is very simple. If there is an authority envisaged as a PIO under the Right to Information Act and some information is sought from him, then his act is amenable to appeal etc. under the Right to Information Act. अगर RTI में मैं आपको ये बोलूं कि मैं आपको बोल दूं कल को आप इंफॉर्मेशन, यू आर नाइदर इंक्वायरी ऑफिसर ना आप PIO, मैं आपको बोल दूं कि जी मेरे को XYZ इंफॉर्मेशन दो और आप उसको गुड फेथ में किसी और को बोल देते हो कि यार ये इंफॉर्मेशन मांगी हुई ये दे दो. हाउ आर यू एमिनेबल टू द एम्बिट ऑफ द राइट टू इंफॉर्मेशन एक्ट? दिस आई डोंट नो हाउ. You engage a lawyer. There are many questions which your officer may have to answer. State Information Commissioner may have to answer. The High Court will not brook this nonsense. Article 220.
और मेरे को तो अभी भी आना पड़ा, बोला 15 के अंदर दे दो और जुर्माना अलग लगा दिया.
तो फिर कोर्ट भी लगा सकता है जुर्माना. You see, there is a very serious problem if the authorities do not know what are the provisions of the statute. That is not the headache of the court and the litigant. If litigant has been subjected to, if मैं वैसी observation दे रहा हूँ, if the court comes to the conclusion that the litigant has been unnecessarily harassed on account of the ये जो है statutory authority, I'll not shy away from imposing costs which may be payable by the state information. Anyways, let Mr. Vishbhushan come. Let him satisfy the court. Wait करो आप थोड़ी देर please, kindly wait. Mr. Bhushan, if the foundation go, everything goes.
Everything goes. Actually, I told my client then that वो उसने बोला जी मेरे से मांग ली, मैंने वो दे दिया उनको.
But Athar Sharma. Yes, Athar. Okay, 346 served. 125 reply file. 346 के लिए कोई आ रहा है? शिवांक आप किसके लिए आ रहे हैं?
I'm putting in appearance on behalf of respondents number 3 and 6.
3 and 6. Shivank Panta has put in appearance on behalf of
Your Lordship. Apparently, there is some confusion inter se as to which counsel has been.
आप फोन करके आ जाओ. Pass it over.
Just to be settled outside the courtroom, of course.
I'll pass it over.
Please, Your Lordship.
Next, please.
So far as this matter is concerned, there is no confusion. I'm putting for respondents number 2 and 4 respectively.
Okay, respondents 2 and 4 served. Mr. Shivank Panda has put in appearance on their behalf. Reply within
4 weeks.
4 weeks list thereafter. In the meanwhile, rejoinder be filed to the reply is already on record. Next, please.
Yes, Lord. I'm highly obliged.
Riders.
My lord, Commissioner.
Yes, yes, so
Matter is 58. My lord.
I think it will consume time. है ना? अगर call भी हो, if you are not here, don't worry.
Otherwise, also, my lord, in that the judgment of the apex court is awaited, my lord.
करता केस लिख लो ना सर में उसमें रिपोर्ट लिख लेना लर्नेड
My lord, may have the last word for last word.
Then learned counsel for the petitioner informs the
Respondent, my lord, and for the respondent petitioner, Mr. Omkar Javed.
Mr. Mahajan informs the court.
The last order, my lord.
Mr. Mahajan has drawn the attention of this court. 20th of March 25 and submits that. The letter is still pending before the Honorable Supreme Court.
Please, my lord.
Accordingly, submit the case be taken up after 6 weeks. Huh?
I'm not in this matter.
After 4, Anshul, Mr. Anshul Jairath.
I thought
No,
he's
sorry, sir, I got
pertaining wise,
confused
my
with
lord. Okay. My lord, we had submitted one proposal for settlement in terms of that. If they can look into that also, my lord.
Up कर लेना बात.
ठीक है जी.
Yes, please.
अब like
Don't worry, take it. Take 3 minutes.
Please, my lord. My apologies.
Yes.
It's in very short order. What I propose to do is this. If you can just give me a little space here because I need to keep outside. My lords, I intend to address the arguments in the following manner. First and foremost, my submission is going to be that there is the need for urgent relief which would overcome a 12A mandate. It is not my case that 12A is not in most cases mandatory. It is my case that urgent relief as spelled out is not restricted to interim injunction.
Nataraj, first demonstrate
that there is an infringement.
It is an infringement.
There is an infringement and that there is passing off.
Then we'll see.
Very well, my lords. My lords will have my plaint and the documents file. To give the background of this case, my lords, defendant number 2.
We were going through the statutory provisions.
The statutory provisions, my lords, section 29. I am relying on 29(1), 2, 3, 6, 7, and in part 8 as well.
Let us see.
If I may describe what our grievance is. My lords, on pages 5 and 6 in the table, I have set out the essence of the packaging of defendant number 1 and 2, which I impugned through various cease and desist notices, to which defendant 1, and I will demonstrate that defendant 1 and 2 are actually connected entities. Defendant 1 gives me an undertaking in July 2024 saying he has stopped use of glucose-D and glucose-C, and of the packaging that he will not do it, that he has recalled all the material, that he has destroyed all the material. In essence, defendant 2 and 1 were first selling a product under the brand name Glucose Spoon-D. My lords will find that in row 2 as well as row 1 on page 5. My lords will have the images at the bottom. Glucose spoon. I apologize, my lord. Perhaps I should have ideally actually blown up these images further, but the packaging at the bottom is Glucose Spoon-D, Glucose Spoon-C.
It is glucose C, glucose C.
Millers, that's the one on top, Millers. Row 1, there are 2 sets of images.
Glucon D.
That's on the left hand side.
And then glucose B, glucose D.
Yes, Millers. Below that, there are 2 packagings. My lords will see that is Glucose Spoon-D.
Glucose Spoon-D.
Spoon-D. In row 2, which is the orange flavor, the first row is Glucose Spoon-D.
So you are not concerned with above 2, or are you?
I'm coming to that also, Millers. I'm concerned with all 3 trademarks. And this is the background Because my learned friend is absolutely right. At the end of the day, an interim injunction or interim relief is founded on equity. Whose conduct is irreproachable, whose conduct is below reproach. And I will try and demonstrate to my lords that even for whether 12A applies and whether I'm showing prima facie infringement in the context of also the bad faith conduct, that there is a deliberate bad faith here by defendant 2 and 1 acting in collusion. I assail Glucospoon-D, for which defendant 2 has a trademark application. What defendant 2 has not filed anything so far, and I understand why, because their trademark application today stands refused. There was an opposition not by me. There was an opposition filed sometime in 2019. They did not file a counter statement that Glucospoon-D stands refused, the trademark application. They continue to, however, market these products online and on their website. Sri Zelco, defendant 2. The second set of trademarks, my lords, I would urge my lords to consider in the following. There is first and foremost the word mark glucose C, glucose D. There is next the label, the overall packaging, so to speak. The packaging has certain key essential elements. My lords is aware that every trademark for a packaging or a trade dress, so to speak, which comes in passing off, there are certain essential elements, and there's an attempt to be as close as possible to the registered trade dress or the unregistered trade dress which is asserted in a passing off. Then there is prima facie an evidence of attempt to pass off and prima facie an infringement, which is why 29(1) uses identical or deceptively similar. Millards, two things I would like to draw my lord's attention to. In the images on the right hand column, which are the defendant's images, which are the products I'm impugning, I cannot say only defendant 2 because the same products are being offered for sale by defendant 1, Karnal Food Pack Cluster. The same products with the same packaging. My lords will see in the column on the right hand side. So here is my label, my lords. Package निकाल देना, वो bag के अंदर रखा मैंने डब्बा. I was remiss in the morning. I had it in my bag. I didn't bring it here. My packaging. Though we have shown it in the plaint. The green pack also, please. If I may just.
Mr. Nataraj, just one thing. Who can be said to be an infringer of a registered trademark? Why I'm asking you this question?
My lords.
Take a case that I am a retailer. Now I have a shelf wherein I have to store all the soaps. I have to store all these glucose items, biscuits, etc., etc. Because now you'll see there is a new ad which is there with regard to this Marie biscuits. That only Parle Marie is the real Marie because there are so many
Maries.
Marie biscuits. So let us take a case that I am a small retailer somewhere in a village. And I've got these 5 soaps lined up, or let us say this glucone lined up. Can I be said to be an infringer?
In law, yes. But may I counter it this way. That is the case
why I am asking you this question is because you are again and again pointing your finger towards defendant number 1
and 2.
According to me, the main culprit per se might be defendant number 2 because they are the manufacturers. I take it.
Millards, that is something which is still yet to come to light as to who makes for whom, but they both show the same product on IndiaMart and on their website.
But who is the manufacturer?
Millards, there's a commonality of directorship. That apart, there is a gentleman called Mr. Sanjeev Chugh who is shown as a sales head of defendant 1 and CEO of defendant 2.
Lord, are the manufacturer of this product?
Yes, Lord. Defendant number 2.
Allegedly infringing product.
Defendant number 2. Alleged.
Impugned product.
Impugned product. Yes.
So you are the producer. You are the manufacturer. Do you have any? I'm just asking. Otherwise, do admit that there is a relation between you and defendant number 1 or not?
No, not at all. Not at all.
You are an independent person.
Now independent.
So according to you, yes, you are manufacturing it.
Yes.
And your manufacturing of the product does not infringe their trademark.
Yes.
That is your case.
Alleged infringement.
Okay. Yes.
Millards. May I begin with this, Millards, to address my lord's question, because this is a question which is rarely false from a court and it really embodies a philosophy of trademarks and why this Trademarks Act is structured this way. Millards, let me take at the base level that I'm traveling from here back to Chandigarh at some small shop outside Shogi. there is Glucon-D, Glucose-D, 510 packets are there. Is that retailer, a medical shop, a pharmacist, is he infringing my trademark? Answer in law is yes. But if I was to sue him, he would be entitled to one defense, and that's the defense of innocent infringement. Because at the end of the day, he's only the retailer.
But the reason why I asked this question to you is that let us directly hit the nail on the head.
My lords.
According to you, your trademark is being infringed.
Yes, my lords.
I take it that it is primarily defendant number 2, because assuming he is the manufacturer of the product. If he stops manufacturing tomorrow, obviously all these advertisers, retailers, wholesalers, they will
stop. It will stop
to the public at large.
Lords.
So let us see as to whether the act.
Absolutely, my lords. Which is why we have drawn this column as impugned products without saying D1 or D2, because what we found is that D1 is also showing on India Mart. The name given as a head marketing or sales for D1 is a Mr. Sunny Chok, who incidentally is the one who has signed the affidavits for D2.
Don't worry.
So that is why I'm coming from, but I'm addressing the products first. I'll come down to the 5Ds, Mala or Bona of D2 later. Millets, the next step is the person who makes. A person who makes, a person who sells. The person who makes, if that person is able to demonstrate A, that they never knew of my trademarks, they would be entitled to the benefit of innocent infringement defense. Or if they're able to demonstrate that my trademarks are invalid in law, then my suit having been filed, if they were diligent litigants as is required in a commercial suit, it was incumbent on them to file the replies in time, challenge the validity of my mark, seek the leave of this court under section 124 to file a rectification proceeding. That hasn't happened. Third defense that they can take, that the two trademarks in question, whether as word marks or the two label marks, in the sense of label marks, that they are visually so strikingly different, or the word marks are visually and phonetically so different that, and here is what the crucial test, my lords is aware, the test of infringement in trademarks is a person of average intelligence and imperfect recollection. A basic consumer who walks into a store thinks, मुझे Zydus का Glucon-D चाहिए, पैक सिमिलर लग रहा है, उठा के खरीद के निकल के गए हैं, बाद में पता चल रहा है नहीं है, it's somebody else. That person is not expected to examine, and this is settled law of the Honorable Supreme Court. He is not expected to take the two packagings of the plaintiff and defendant side by side in the shop.
In this case,
Lords.
there may be a subtle difference. This is 5 itself.
My lords.
Now, even as far as passing off is concerned, that is why I'm requesting you that please strike the nail on the head. How, according to you,
my lords,
product can be termed to be as passing off of yours? Why I'm asking you? You see, let me give you an example. Ordinarily, whenever an Indian goes to a shop, अब तो नहीं, अब तो खैर सारे पढ़े लिखे हो गए हैं, टूथपेस्ट जब मांगता तो कहता तो Colgate दे दो. Colgate used to mean
लाल कलर का टूथपेस्ट.
Whenever someone went to a shop and said कि मेरे को पॉलिश की cherry blossom दे दो, तो cherry blossom, day before yesterday I was just telling someone that ki yes, what is this? He said these are Xerox copies. So I just reminded him that there is nothing known as Xerox. Xerox is a company.
But I'm so grateful my lords has taken this example, because till I think it was till 2014 or 2013 in the Honorable High Court of Delhi, in the original building, if my lords have seen it, where the bench was sitting, right before the bench there was a big printout saying kindly hand over paginated Xerox copies. Till the IP bar had to approach the Chief Justice, learned Chief Justice then, and say, sir, please stop saying Xerox copies. That's an infringement of trademark. That's a misuse of the trademark.
So now in that light, because
in that light, my lords, and this is
so if I say give me Colgate or किसी ने को पकड़ा दिया, या there is a, you see, infringement when I go to a shop seeking a particular product. For example, I say कि मेरे को Strepsil चाहिए, or someone gives me Strepkill, same everything, CIL, CILL, Vico turmeric. There is, and I'm not to make, I'll tell you, there is Vico turmeric and there is one Nico turmeric. If you go to any small markets, वहाँ पे आपको Nico turmeric भी,
Mango Light, Mango Bite,
Mango Bite, Mango
Light.
So in that perspective, how according to you, whatever they are doing, it amounts to passing off?
Lords will permit me to address that question.
Because I am today only hearing you for the purposes of interim.
Interim.
उसके आगे
My lords will permit me to address that.
That with 12A.
Yes.
Otherwise,
Con-
my friend will take offense to it.
Because we have moved already one application under order.
Don't worry, dear.
So therefore, my lords, whatever submissions, my lords may take it, that whatever submissions I'm making in respect of the urgency of relief, which may be seen as a partial answer to the 12A stand, and the question posed by this honorable court, the 12A stand by my learned friend, is on a demurrer because I've not filed a reply, notice is not issued. Nevertheless, is on a demurrer. My lords, my position is twofold. For infringement, intent is not required. First, where it's identical. Second is deceptively similar. The intent or the motive to deceive is partially relevant. So my lords will therefore bear with me when I take my lords through this table and the conduct of this defendant as set out in the plaint and subsequent to the filing of the suit and prior to the filing of the suit. The conduct becomes very, very critical and crucial in ascertaining whether there is an intent to deceive.
Why I'm asking you, you see, let us assume that there is an advertisement of a scooter. Obviously, they'll be showing two persons riding on it. Can someone take an offense कि भैया इसने भी scooter की advertisement दिया है? He's also showing two persons only because your primary plank is happy family. But naturally, some other party.
My lords may take it. Live in times of extreme unhappiness, where perhaps a little light-hearted banter helps lighten a heart. But that is not my primary plank, Millers, and that is where
because
one by one.
I'm just
first and foremost
these photographs as a prudent person as to whether I will be deceived.
My lords was then, unfortunately, may I say, my lords perhaps attempting to pass oneself off as a person of imperfect recollection and average intelligence, which my lords is not.
No,
but there is an onerous task here because this court is then required to assume itself of its legal.
Just putting myself into the footstep of a person who will be standing 3 rows down in a chemist shop and asking कि यार एक glucon D दे.
Glucon D चाहिए.
That is
that is test number one. In the context of online marketing, it is somebody who's scrolling through, sees something, just places the order or places inquiry. Actual purchase is also not required. The fact is, so to speak, if I may borrow what I studied in contract law in 1988, it's an invitation to treat.
Exactly.
Let's. So my lords will first allow me to show the packaging. So when it comes to packaging, what is material are not the dissimilarities, but the similarities. I am pegging the similarities on the following, and I'll first take the glucose D, glucose C similarity. My lords will see, I write glucon-D. My lords has the left-hand column.
Yes, just give me 1 minute. Yes.
I write glucon-D in a stylized form. I put it on a geometrical background. The geometrical figure I use is a triangle. Good, bad, whatever be the context or relevance of the geometrical figure, I use a geometrical figure there. I write the phrase instant energy below it. My lords, I have the actual product.
Just give me half a minute. Just show it to me, sir.
Millers.
I have the magnifying glass also, but
I apologize, my lords. The annexures have it in a much clearer fashion, but my lords will permit me to.
Yes, glucon D.
Glucon D in a white triangle white geometrical background. Just below glucon D is a phrase instant energy, which I've been using from the beginning. On the right hand side. If you have a green one, sir, perhaps that would be of help. Or my lords, I think that's the. I can give one that is as close as possible. It is not yellow, but it's orange.
Yes.
Or in other words, it's a rang biranga khel.
This is yours.
This is mine. Orange pack in a jar. My lords will see on the right hand side, there is a yellow double-headed arrow, which has on it written, my lords will see those 4 bars in green. Those are supposed to represent a battery. The life of a battery as we see on a mobile phone, etc. Then my lords will have the word instant energy, a double-headed arrow. Adjacent to that is the image of for want of a better term, because this is a phrase the client has been using for God knows how many years, a happy family. The logic or purported logic or alleged logic or apparent logic based on market surveys, ग्लूकॉन डी लेंगे तो खुश रहेंगे, एनर्जी आएगा, तंदुरुस्ती आएगा, etc etc. My lords, may now see defendants one packaging which is the glucose D. Now that one of the defenses they have taken in the written statement which is on record but should not be on record is that, and in the cease and desist reply of October 2024, the defense they take is glucose is a name of a substance. D stands for vitamin D.
Some green one. Okay. Yes.
D stands for vitamin D. Therefore, glucose D is generic. This is the defense they have taken in the cease and desist reply to cease and desist in this, October 2024. They reply to my cease and desist. Second, their defense is everybody uses happy family. Everybody uses green color backing. There is no monopoly over something that is publicized juris. I asked my lords, if I was to put myself in the position of someone, as my lord says, I have played football, hockey, cricket, whatever, or war games on television or on video, which seems to be the latest fad amongst youngsters. I am tired, I'm sweating.
Glucon D is your trademark.
Glucon D is my word mark. This label itself is a registered trademark.
That's a word mark.
Glucon D and Glucon C are my registered word marks.
ये जो glucose C, glucose D, are they registered word marks?
No.
They are
No.
not registered.
No. Yeah.
Okay. Number two, ये जो pictorial depiction on these boxes, are they registered trademarks?
No.
They are not.
They are not. They are not.
They are not. They are neither your registered trademarks. Okay.
We are using it as our brand name only.
Brand name. Okay. Just please.
In fact, perhaps that makes my case easier, because my lords, a trademark is a trademark is a trademark is a trademark. When does it become a brand? It becomes a brand when an attempt is made to use that consciously, willfully, deliberately to create an association in the minds of the public with my product. If they have been using it as a brand, which means that they intend at all times to use it as a trademark, that they are claiming a trademark right over it. Lords has this, and this is a perfect example, because my lords,
मेरे को आप एक चीज बताइए before we proceed further. What is a word mark? I have never heard this.
Word mark is, my lords, a simpliciter word. So,
but you just, I was slightly hesitant in asking, but you yourself answered it. You said it is a registered word mark. So it is registered under what?
Under the Trademarks Act. So, Trademarks Act allows me to register any device, word, label, etc., which in the minds of the public can create an association of the product with me.
I take it that this entire thing is registered under
The label is registered. The green one isn't, the orange is.
This is not.
The green label is pending application. It is likely to be registered very soon. I'll have to check the status in all fairness. The orange label is registered. We've given that. So the whole label is registered, not the shape of the bottle as such.
One thing is there.
Millets.
Assuming that there is no registration of your Glucon D green label, then there can't be any violation of the Trademarks Act.
Millets.
This particular product.
There is a violation in the sense, then we come into the realms of passing off on an unregistered mark, for which a pending application is pending. And the Trademarks Act draws a clear distinction between registration leading to infringement and passing off, which can be for registered and unregistered trademarks. Because passing off, I only have a slightly higher burden of showing that the reason why defendant to copy that whole, so to speak, get up or the layout is so as in the mind of the public to be as close to me as is possible, so that the average public thinks ye jo product hai main aur koi bana raha hoga, they don't know that, but they assume it is my product because of the imperfect recollection in their mind. My lord, if I may give an example, my lord will permit me to name, and there's a burden in many ways that I bear. From our childhood, we have been using Nataraj pencil. Nataraj is always written in gold on a background which is black and red, alternating stripes of black and red. Camlin Flora, white base with pink flowers, and Camlin or Camlin Flora written on it for the pencil. My lords, Nataraj would be a word mark. Now, if I register Nataraj as a word mark, it entitles me to protection against anyone who uses that word irrespective of how they use it. I may get it in all capitals. They may write it in italics, lowercase. They may write it in Hindi. They may write it in Tamil. It doesn't matter. If it's Nataraj and I have a registered word mark, I have protection for infringement. It doesn't even have to be in gold.
Something I don't know. There's something which is bothering me is, you see, they are producing an item. They are manufacturing a product. Their product is in market. It is being consumed by human beings. So, as far as trademark is concerned, it is one thing. But who gives the license to manufacturers like the plaintiff and defendant number 2?
Let's say it would be the Food Safety Standards Authority,
There is no,
FSSAI,
as far as
but they don't give it on the basis of trademark.
they don't give it on.
They don't look at the trademark at all. They're only saying glucose powder, you have a license to make and sell. Glucose powder with vitamin D, you have a license to make and sell.
Thereafter, it is a fight between 1 and 2.
That is under the Trademarks Act. There's a separate fight. If I have a problem,
Will only certify that it is good enough, that whatever
Good enough for consumption.
it is good enough to be consumed by human beings.
Yes. Safety
the
standard.
product inside the label. So the safety standards doesn't look at the label. In fact, the Trademarks Act itself provides alternate remedies. If, for example, I as Zydus Glucon D decide to.
But when someone, though I may be going off the track, if someone manufactures these kind of things under the Food Safety Act also, when he applies, I'm 100% sure they must be filing applications, etc., specifying therein as to why they intend to manufacture the product.
Yes, why they manufacture? I may say this today. If defendant 2, I'm saying this, Millets.
I may put it very, very crudely. What is the need of
labels?
Labeling it. I'll tomorrow, let us assume I manufacture this product and I say that I'll sell it as chitta. It is something chitta. मैं कल से चिट्टे का level लगाऊंगा. Can anyone stop me? I'm just asking.
No, Millets. If you have a license FSSAI, no. And which is why it is my considered position as Zydus on instruction from the beginning. If any defendant or addressee of a cease and desist notice wants to sell glucose powder,
he can do it.
Containing vitamin D, containing vitamin C, let them put in vitamin A to Z. Let them put in calcium, phosphate, whatever. They are free to do it, but not glucose C and glucose D, because that causes a problem. Because then very honestly, Millets, I am not going to go down necessarily only on the ground of public policy, public interest. Trademarks Act is founded on public interest. I have a twofold interest here. If there is a problem with any defendant's product which has glucose C and somebody has bought it thinking Glucon D, I could potentially be subject of consumer liability apart from health concerns, because they will simply say Glucon D ka kharida kharab hai.
As far as trademark is concerned, trademark only gives you a protection
for the labeling outside, for the word, not for the product.
Not only that, you see, as far as trademark is concerned, whatever little knowledge I have, at the end of the day, two products will be similar. Why I'm saying so? Let us take a case. जैसे आपने अभी बोला कि I'm only bothered if someone sells glucose C. It's just like saying that, let us say that there are 5 cars in the market. If there are cars with 4 gears, then I give a damn because I'm a 5-gear vehicle. But if some other vehicle comes with 5 gears, I have a problem. You can't have a problem, because if you can manufacture 5-gear vehicle, so can some other person.
Absolutely.
The only thing is that if yours is Ciaz, I'm just giving, or let us say Honda City, and you have got a particular packaging, etc., or something, someone should not bring in a similar product and pass it off in general public so as to befool the public who may buy it or consume it thinking it to be yours. That I think
that is the essence of trademarks. That's the essence of trademark. May just take on from the example that my lords gave. Honda City. Suppose you are wonderful. Tomorrow I showroom here and start selling Hyundai Pity. Then my lords is faced with, assuming my lords is faced with the trademark suit here, my lords will have to adjudicate who's the consumer who's likely to buy a car. Is that person likely to be confused between Hyundai and Honda, City and Pity, or Pity and City? But let me give another example. I think it is in Shogi again or Dharampur. Lakshmanji ka Besan Barfi, famous all over the country. My lords, every time I go here, I receive an order from my office about 7 kilograms I have to take back with me. They've told me travel by road, but take it back. If in Delhi, I take the Barfi out, keep it at home, buy something from some local shop in there and put it in the same dabba and sell. Or I say, Lakshmanji nahi, Nataraj ji ka Barfi with the same pattern layout, am I not defrauding the consumer?
Honestly speaking, I'll just give you an example. At Shogi, there is a very famous Sharma Dhaba. So once I was traveling back from Chandigarh, I had never been to that particular dhaba. So we decided that we'll have dinner out over there. I didn't realize that there are two Sharma dhabas out. So I was coming from Chandigarh, so I saw this Sharma dhaba. I saw, we ordered. Then I suddenly realized that it neither has the ambience, nothing else. Anyway,
So that is all. Somebody is deceived into walking into that restaurant.
As soon as I paid the bill and came out of that shop, after 10 meters, there was this famous Sharma dhaba.
Sharma dhaba. Millets, if my lords will permit the liberty and my learned friend will permit this, when I moved independent, started my independent practice away from the earlier firm I was with in 2012, one of the first clients who came was somebody who had Mama Yadav ka dhaba. He paid me 5,000, the princely sum of 5,000, and it's a huge amount when you just started practice. For a trademark advice, we filed the opposition. Turns out it was against his uncle. He has Mama Yadav ka dhaba. Now they have it near Murthal. This was in Hapur in Uttaranchal on that UP road. His uncle had opened a dhaba 100 meters ahead called New Mama Yadav ka dhaba. His cousin or another relative had opened 100 meters before saying yet another New Mama ka dhaba. So this happens. The problem is the consumer gets confused and the consumer is defrauded. Or they may not be actually defrauded. And this is where the principle of initial interest has come about. It's not even my lords that my lords or I or any average person, a consumer will walk into the shop and pick the product. Is the person going to the shop looking at that packaging from a distance saying, Glucon-D hai, main jaake khareedne wala hu. Mujhe chahiye. That is a concern. And here are the elements which are copied. And these are the elements which the Supreme Court says we have to look at the similarities, not the dissimilarities. My lords will see that green jar which my learned friend has handed over. Now that trademark there is Glucospoon-D. That application was filed by them. No counter statement filed. It stands refused today. As of 2023. Glucospoon-D. The family package, the family face. Well, a person walking into a store doesn't see 3 log hain, 4 log hain, 2 log hain. 2 log is a truly happy family. On a lighter note, but 3 or 4, whether India is following whether the client is following the 1-child norm or the 2-child norm, it doesn't matter. The fact is the impression is there's a happy family there. Immediately below that, my lord sees ribbons. Then my lord sees on the side fastest energy yellow bar with battery symbol. And Glucospoon-D written in a geometrical background. What is the test? And I asked myself this question: what is the test here? Initial interest for a person of average intelligence, imperfect recollection. I have been using Glucon-D. Now, whether I've been lured to buying my client's product because it looks attractive or because of the quality is a separate issue. But I'm used to this packaging. I see this row of Glucose-Ds.
You see, nowadays there is one more thing which has to be kept into mind is the names of these MNCs. They are changing so fast. Someone can very easily say, "Sir, ये वही चीज़ है, अब इनका नाम बदल गया हुआ है." This is also one of the. This can also be
happens all the time.
No one will be disputing or challenging कि हो सकता है बदल.
We go for example and we say Crocin. When we mean the brand Crocin, but somebody says, "अच्छा जी ये Dolo है, वही चीज़ है, वही company है," because the packaging is blue and white. So that is the confusion level which has where my lord says the onerous task of assuming, putting my lord says to take oneself away from this bench, and as somebody who's driving past sees this in a pharmacy or somebody who's going online to order, and is there or is there not an initial interest confusion? Then comes the second part. Was this done deliberately or was this inadvertent or accidental? My lords will see this is on Glucospoon-D. It equally applies to the Glucose-D packaging that they use. Glucose-D is not written in plain script. It is written in a stylized form. Trademarks are usually 99% of the time stylized.
So your contention is that this Glucospoon-D trademark application of the defendant has been rejected.
Has been rejected. My lords, I have the copies here.
Maybe
sorry.
Issues of record. Now he's just.
But let them deny it, then that is not refused. It's their trademark.
You are instructing counsel.
Is it refused or not?
We'll have to confirm.
My lords, this is official from the trademark registry website.
It's just coming from him.
My lords, is it refused? Is their trademark application refused or not?
We'll have to.
See, Please ask your instructing counsel. He can inform us.
He says that he'll have to have.
So have instructions in the meanwhile. Have instructions. Yes, please.
My lords, this is only for the purpose of information that the word glucospoon-d as written in a stylized manner. My lords will see on this first page on the top, abandoned. As on date is not the date of abandonment, it's the date on which this printout was taken. My lords will have the second page.
Anyway, I take your word for it. We'll let us.
Because the third page has the order of abandonment of 2023. It can't be that the client did not know it and did not inform the council.
In law, if let us assume you have applied for this particular and in anticipation that this trademark will be registered, you have started manufacturing and selling your product by using this particular trademark. Supposingly tomorrow your application is rejected, then what is the legal effect thereof?
The legal effect is this: if I have a registration, then I have the defense of a registration, and under the act I can't be injuncted for infringement or passing off. A registration is my best defense in a trademark suit. Otherwise it is of no consequence. I will then have to show
thereby that even if his application has been rejected, he can still
he can sell, but he runs the risk of being injuncted.
Yeah, may I say one thing? Because I've just read it. It's a case where he has not pursued his application.
So
the result thereof, it's an abandonment.
Meaning thereby,
he can always pursue it.
Meaning thereby that you do not have any trademark as far as this goes.
Yes, that is there.
Insofar as, my lords, may I clarify this in fairness, insofar as this word glucospoon D written in the stylized manner is concerned, and may I only add on here, my lords, it's not that he did not pursue. It is that he did not file a reply to a statement of opposition, which has a consequence is the same as not filing a written statement. That's the same as not filing a written statement in a suit.
And
there's no defense.
Okay, proceed.
My lords, assuming there is no registration, there's only an application which is refused. Can they be stopped? Can they use this? They can use this, but they're laying themselves open to a risk of injunction. Somebody comes forward. The next element, my lords, is on the glucose-D label. My lords will see, I admit, they're using a boy playing football. That's the image there. But the same ribbons, the same sidebar, fastest energy, in the yellow double-headed arrow, with the same battery symbol, glucose-D written stylized trademark style, in a geometrical background. My lords, may I respectfully submit, the overall impression for a person of average intelligence is, ye wohi cheez hai, le lo. It's only perhaps when they go in and that they may be able to spot the difference. They may be told by the chemist or the retailer.
Again, there may be a slight difference. Let us assume, I'm just giving hypothetical examples because I'm just pondering while I say so. You are selling pranthas, okay, with makhan and let us say some achar and let us say some hari chutney. He also sells something which is akin to a prantha, but from the plate it is very, very decipherable that his main product is quite different from your product. Can you say that no, it still amounts to passing off? Because if you minutely see, the color of his chutney has some resemblance with my chutney, and he also uses some pickle as is being used by me. Or will it be at the macro level as to someone? Because passing off of this with this, it may be slightly hypothetical.
May address my lords directly on.
As a consumer, I'm not going to see you bar dikhana, ya niche dikhana. I'll just have a glance at this and I'll just have a glance at this. See, this and this, okay. This and this, okay. I can understand. But this may be slightly.
My lords will permit me here. There is perhaps a difference between the example that my lords gave. The paratha is the product. The paratha is not stamped G. Nataraj paratha with embossing. The paratha is a product.
Let us take
I am again coming back, my lords.
That I am selling those microwave heated pranthas, and he's selling those microwave heat. बताओ भी जल्दी से कोई मंडी में क्या बनाते हैं आप?
That's pizza.
नहीं मंडी में पिज्जा कहाँ से बना? कचौरी it's just akin to. And there are two ये जैसे लिफाफे नहीं होते हैं, and you go to a fast food और एक तरफ परांठे का पैक है और एक तरफ उसी का मंडी की कचौरी का है. And if you have a look at the product per se, that will be printed outside. It will be just akin.
My lords will permit me this. The product in question is not this packaging.
Product, I'm asking about the trademark.
The trademark.
Obviously, Let us assume that there are two trademarks. He also has something round in that trademark, and you also have something round.
This is one of, perhaps if I may share something I overheard in the Honorable High Court of Delhi, which is now equivalent attempt at passing off has also happened in the neighboring country. Starbucks, they entered India. They immediately after 6 months, 7 months, somebody started Sardar Baksh. I'm not joking, Millers. It actually is a case with the Delhi High Court. The same logo, except where Starbucks has the mermaid in that green image, green and white. This had a venerable Sardarji. In the neighboring country, it's Shah Baksh.
Burger, kaun sa burger? King Burger and
King Burger, Burger King.
1001.
So, which is where I'm coming from. Even today, I say this, and on instructions, I do not have a problem with defendant who sells glucose powder, whatever name they may want to put in it. But when they sell it as glucose C, glucose D, or glucose spoon-D, on which they don't have a right anymore, using packaging of this nature, there are two separate levels of infringement. Infringement number one is of the overall packaging, which is glucose spoon-D, which has a happy family. Second, and I'm not on passing off, Millers, because passing off is a different action. That's an action in tort. This is a statutory action, I'm saying. My trademark in the label has yellow bar with instant energy, geometrical figure, glucose D written in a glucon D written in a stylized figure, etc., stylized manner. I'm saying that that packaging, you may use a boy of image of a boy of playing football, but the imagery is deceptively similar to mine. Intent is less relevant there in infringement. That is my respectful submission under 29(1). Now, when we come to 29(2) and 29(3), my lords, 29(2) has three separate categories.
It's identity with the register.
Identity of the mark and similarity of the goods or services. Second is similarity of the mark and identity or similar goods. Third is identity of the mark and identity of the goods or services. It is surely an admitted position that identity of goods exists. We are both selling glucose powder. I'm not into the quality, but as a category, we are both selling glucose powder with vitamin D, with vitamin C, with whatever. We come to the question of identity of the registered trademark, and this is where Millet's 29C, 2C is also crucial, because I'm relying on that also. Because in 29(3), a statutory presumption comes in that the court shall presume that confusion is exist. My lords will kindly consider the first packaging. Identity doesn't mean absolute copy paste identity, because the test is again
first blush.
Perception.
At the first blush.
My lords has probably put it better than what any English author could do. English authors go down the initial interest confusion. IP lawyers tend to complicate it even more. The first glance test. At first glance, is there an identity? My lords, I ask myself this question: if I walk into a shop or I go online, I go on IndiaMart or Trade India or whatever, I search for Glucon D and I find Zelco Glucose D, whether it has a football playing boy or a happy family apart, that's not the only thing I look at. I look at the packaging. And this is why the documents, subsequent conduct becomes relevant. On IndiaMart, Shri Zelco sells a product showing that orange dabba of theirs. They have not brought the orange dabba and the green dabba. That, my lords, is mine. They have not brought the jar. The jar is here. My lords, may imagine or visualize the same jar. That is my jar.
That is yours.
The orange one is mine. The green is theirs. But the green is glucose moon. I'm on glucose D. My lords, will have this yellow jar, glucose-D, boy playing football, yellow bar, all of that. Next to that is written Zydus Glucon D. Somebody goes on IndiaMart, what does he see? Zydus Glucon D. Yehi hoga, kharid liya. The attempt is to create that confusion, and that is what trademarks law is meant to stop. And that is why there is a presumption of likelihood of causing confusion. Next we come, Millards.
Where is that Glucon D?
Millards, we have it in the additional documents. What we have done, Millards, is though there's no reply on record as such, we had prepared a rejoinder ex abundante cautelon on a without prejudice basis. We have given them a copy. Millards, rejoinders. We have an extra printout. Millards will permit me. I can tender it across the bar as well. Rejoinders.
Let us. Or niche file kar dena apne ko.
We'll file it, my lords, but for my lord's reference, may see this, please. My lords, as any action basing on deceptive similarity, my lords should come to straight away to page 35. Sorry, my lords. Page 32, which is India Mart listing for Sri Zelco Foods.
Yes.
This is Sri Zelco Foods Private Limited. This is their India Mart listing. My lords, may flip the page. My lords, may come to page 34. At the top, it says Sunny Chugh, CEO. View mobile number. My lords, may then come to page 35. My lords will see on top. And I don't know what is more galling to Zydus, because I'm fighting a battle with Dabur for the past 19 years on the Glucon C, Glucose D on packaging. That's a ding-dong battle going in Chandigarh, in Gurgaon, as well as in Calcutta. Ultimately, we expect this year the trial will get over. My lords will see on top, it says Dabur Glucon D. My lords will see the packaging, their packaging. My lords will come to the bottom of the page. Zydus Glucon D. Who uploads this? India Mart stands and says, I am not an e-commerce website. I am only an intermediary. Is D2 has uploaded? Does D2 say they did not upload this content? Can this be done by India Mart? In which case India Mart is culpable. If it is done by the subscriber, which is Sri Zelco Foods, then Sri Zelco Foods defendant 2 is culpable. Why are they using Zydus Glucon D? And this is where the conduct and 12-way aspect also comes in, my lords. 2023 April, I send them a notice for Glucospoon D. They don't reply till July 23. I sent another notice in May 23 to both defendant 1 and defendant 2. They come back and say Glucose C, Glucose D are our brands, our marks. I'll take my lords to the document, their reply of 2023. We don't find the products. Then 2024 April, I sent another notice, to which a reply comes in July, or comes in October. My notice of April 23 or April 24 is replied to by defendant 2 in October 24. A defendant which waits 6 months to answer a cease and desist notice surely cannot plead delay.
No, but question is, you please let us know, come to the cause of action.
Cause of action paragraph, minutes.
Para 90.
Page 57, minutes.
90.
Is as recent as September 2024. And I say this for defendant 1. And this is the reason. It has always been our impression. It has always been what has been held out by defendant 1 and defendant 2, that they are connected entities. And my lords, I'll show it from the plaintiff's documents filed with the suit that they are in fact connected entities. In July 2024, defendant number 1 sends me an undertaking saying, I have stopped doing it, I won't do it, I've taken down everything. We find it continues, we send him a reminder, a polite reminder saying, आपने undertaking तो दे दिया पर आपने हटाया नहीं है, please हटाइए listings. What is the product they were showing? Sri Zelco's product. It's not that there was some small retail chemist or a retailer on the mall. This is a big time agency which advertises extensively on India Mart and sells it extensively, and the connected entities. Millers may then come to the next paragraph 92.
You see, Mr. Nataraj, if you come to your pleadings page 10 and 11 of the claims, you yourself admit that the infringing activity, now I am concentrating on defendant number 2. According to you, the infringing activity commences in the month of April 2023. If that is true, then why 12A has not been adhered to?
My lords will permit me to address this. And I'm deeply conscious that perhaps I have here the task of distinguishing judgments of this honorable court, both single judge and division bench, as well as the honorable Supreme Court, and construing them in perhaps as harmonious a manner, and obviously in a manner that is most convenient to me. My lords, number 1, I will begin straight in Novenco. Point number 1, Novenco was a case where a cease and desist notice was sent, nothing happened, then it apparently went for testing. It's a patent case. My lords is aware, it was my lord's judgment, if I'm not wrong. They say they sent it for testing.
Yes,
the person took 1 year to test. There was no reminder, no follow-up, no nothing.
Every case is decided
on its own facts.
What is good in A might not be good for B. So let's not be the slaves of our own judgment. You see, according to me, I may be right or wrong. If I am Mr. Rajiv Jivan, my contention would be that if today, according to the plaintiff, there was an infringement of the trademark, he should have rushed to the court immediately or within some reasonable time, and he should have had obtained injunction against me. And as far as this cease and desist, etc., collateral tha, ye chalta rehta. But once you yourself are indulging in all these cease and desist, you say he is infringing since 23, he is infringing since 24. Then Supreme Court says that in these circumstances, don't rush to the court. Resort to 12A. If 12A is unsuccessful, then come to the court.
Lords, may I?
So now the moot issue will be.
Moot issue.
Which
How do I justify my 1.5 years?
Not only that, what happened in the near vicinity to
January
2025?
Millards, these are the things that happened.
To come to the court rather than resorting to 12.
Millards, I'll put it this way, Millards. First, on a slight theory basis on why is 12A present. 12A was present, and I may say this, Millards will pardon me if I sound impertinent, was not there to reduce the burden of the courts, was primarily that commercial disputes which could be resolved through alternative dispute resolution should be resolved. The added, so to speak, benefit is the workload of the courts also comes on, which the Supreme Court recognizes in Yamni Manor and Patil automation. The second objective is the parties must show an indication or a willingness that they are actually amenable to even discussing it, that they're not parties which will use. My learned friend rightly said, Supreme Court in Yamni Manor says, I can't use my 39(1) and 2. I shouldn't use my 39(1) and 2 as a mechanism, as 4 pieces of paper to bypass 12A. Likewise, the contra is also true. Every coin is a head and a tail. A defendant cannot say 12A, simply stand up and say 12A and say 12A, you didn't exhaust. Therefore, 39(1) and 2 can't be granted. It has to be seen holistically. And my lords is right. What has happened with 12A is the burden is entirely on my lords.
Speaking for myself, 39(1) and 2 and 12A, though are connected, but they may not be having any connection.
They may not.
I may entertain a civil suit.
Absolutely, my lords.
Directly before me, refuse 39(1) and 2 and still say that he has bona fidely come here. I am not allowing 39(1) and 2.
Absolutely, my lords.
But he was correct in bypassing 12.
Millards, that is what the erstwhile Chief Justice, when giving the decision in Yamni Manor, so beautifully records. It doesn't matter if ex parte is refused, not given. It doesn't matter if ad interim is not given. It in fact doesn't even matter whether interim is given or not given. What matters is does my plaint and the documents I filed for a case of urgency.
Precarious situation, assuming you come here and you get 39(1) and 2, you get an interim. Mr. Jivan goes to the Honorable Division Bench and the Honorable Division Bench vacates.
Sets it aside.
What will be the effect? The plaint will be returned back that no?
It can't be.
Or converse.
12A.
I refuse 39(1) and 2 and say, no, 12A, go there. You file an appeal and you succeed. So it is a very precarious.
It is. A 12A cannot be literally backdoor mechanism for a 711 or a 710. Millards, I have to travel back to Delhi, Millards.
We'll continue.
Perhaps Millards could consider my lord's convenience and my learned friend's convenience. First week of June, Millards.
He's happy sitting out over there. Very happy here.
The only reason I'm saying this, my lords, is this. Unfortunately or fortunately, my lords is aware my home bar is Delhi. And this is the closing week.
I have now got, as far as this passing, rather this infringement of 29 is concerned. To some extent, I have followed what is coming from you. To some extent, I have followed. And I'll hear you more and I'll hear the Learned Senior Counsel also. But first of all, we'll have to cross the threshold of.
Have to show urgency.
A now. And harmoniously with 39(1) and 2. Because if the court is of the view that no, because you have waited for 2 years, you could have also waited for 2 more months.
Millards, may only say this. I will endeavor on the next occasion, when my lords permits, in 15 minutes to demonstrate, to answer that basic मुद्दा क्या है. मैं आज क्यों आया? January 1 तारीख को जब पूरी दुनिया न्यू ईयर सेलिब्रेट करी, मैं शिमला क्यों आया फाइल करने के लिए? I will demonstrate that through the facts and the documents.
Lighter side, I will just mention an amendment made in the application. In spite of multiple notices and efforts being made by the plaintiff to communicate and amicably resolve the matter. The intent was to amicably resolve the matter instead of resorting to the mechanism of mediation.
And one more thing, you filed the suit on 1st of January. So today we are in the month of May. No interim.
That is what the Supreme Court says. The fact that you did not get it for 5 months does not mean that you're not entitled, that you get hit by 12A.
I'll fix the date of audit.
Let's go first week. My lords, could perhaps first week. I understand that in the first week of June, Ms. Carol has.
I don't know, but I won't be available from second, third, and fourth.
My lords, could perhaps, if I may request, I know I'm perhaps, and my learned friend perhaps I know will not use this. He's a very fair person. I have another matter before this honorable court on the 17th of June. My lads could, so 16th of June, perhaps.
Fine, it's fine.
16th of June.
Heard for some. You file this application. I'll take the.
We'll file it. We have served them. We have served D4 2. We give D4.
Milord, we have moved one OMP under order 7 rule 11.
You file reply to his application.
We'll file reply to the 12A also.
My application.
Then I accept notice reply by the next date of any list.
My lords, they filed 2 applications. One is a 711 and a condemnation delay.
Put some glucose to him.
My lords, they have 2 applications. One is a 711 and a condemnation or delay. I'll file replies on both in.
And reply by the next date.
My lords, will file a reply within 2 weeks in case they wish to file a rejoinder. No, in case they wish to file a rejoinder, my lords,
OMPs may notice, accept notice, list on 16th, pleadings be completed in the meantime.
Very well, my lords. I undertake to my friends, I'll file it within the next 10 days.
Please take away your energy drinks. Okay, thank you.
Deeply obliged, my lords.
Thank you, sir. Date of Lena. Yes. Meena Kumar. Mamta. Yes, ये क्या है? बुलाओ, Mr. Bhuti.
Thank you so much.
ममता, मिस्टर विश्वभूषण, आप आओ जरा, आपकी एप्लीकेशन, मिस ममता, ये आपका केस है, आपने की थी बात, क्या बनेगा इसमें, क्यों?
लॉर्डशिप वो उसका ये मानना है कि लॉर्डशिप वो मिली थी उससे सेंट्रल जेल चंडीगढ़ और या सेंट्रल जेल नाहन में लॉर्डशिप, पर उसकी जो मेंटल सिचुएशन है, बोलते मेंटल सिचुएशन खराब कर चुकी है पूरी की।
आगे कर दूं चुपचाप से।
प्लीज लॉर्डशिप, प्लीज लॉर्डशिप।
लिखना ऑन हर रिक्वेस्ट लिस्ट इन ड्यू कोर्स बाय 2, बिकॉज अगर मैंने डिसमिस कर दिया आपके दुआले हो जाएगी। सही कह रहा हूँ?
4 weeks, after 4 weeks.
लिस्ट इन ड्यू कोर्स।
लॉर्डशिप,
सर आपकी एप्लीकेशन कैसे मेंटेनेबल थी?
लॉर्डशिप, here लॉर्डशिप,
इंक्वायरी ऑफिसर वाज नॉट द PIO, देन हाउ वाज द एप्लीकेशन मेंटेन?
नहीं जी, मैं ये नहीं बोल रहा हूँ ये एप्लीकेशन देखें जी, P1 जो मेरी एप्लीकेशन,
रिकॉर्ड दिखाओ।
जो प्रिंसिपल है ना जी, he is having 2 posts लॉर्डशिप, as PIO कम प्रिंसिपल, as IO कम प्रिंसिपल लॉर्डशिप। सो पहले मैंने इनसे इंफॉर्मेशन मांगी कि जी इंफॉर्मेशन तो क्या, मैंने इनसे रिक्वेस्ट किया कि आप मुझे जो है वो ये डॉक्यूमेंट्स दे दें, ये दिस पर्टेन डज नॉट पर्टेन। नाउ दे
RTI के एप्लीकेशन कहाँ है आपके और किसको दी हुई है? फ्रॉम वेयर डज दिस सेंटर इशू?
रिप्लाई बना दिया है जी, मेरा रिप्लाई तैयार है जी सारा।
आप ऐसे करो ना, रिप्लाई रिव्यू तो बनते रहते हैं, फिर आप ये बताओ कि आपकी एप्लीकेशन कौन सी है जो RTI में दी थी, जिसे
वो दिया जी मैंने, वो दी मैंने 22/4 और 22/7 की एक इन्होंने रेफरेंस दिया कि भी इसके अंडर हम आपको नहीं दे सकते इंक्वायरी रिपोर्ट और ये सब, तो ये इन्होंने डिनाई कर दिया। मैंने कहा तो आप ये मुझे बता दो कि 22/4 और 22/7 ये कहाँ हैं, ये प्रोविजंस कहाँ हैं लिखे हुए?
सर वेयर इज द एप्लीकेशन फाइल्ड बाय यू सीकिंग द इंफॉर्मेशन?
तो मैं उसका कल दे देता हूँ।
सर मैम आपने रिकॉर्ड दिया था ना मेरे को भी, ये रिकॉर्ड इस वाली फाइल में दिखाना है। हाँ? 3 फाइलें दी थी ना आपने मेरे को, कि और भी दी थी? RTI एप्लीकेशन आपने दिए 13/5/24 को। 13 कम प्रिंसिपल इंक्वायरी ऑफिसर।
नहीं जी, मैं 16/10/2023 की है जी मेरी पहली।
वो दिखाओ कहाँ है?
ये है जी, P1 लगाई हुई है, P1 विद द पिटीशन लॉर्डशिप, पेज 18।
ओके, थोड़ा 10 पेज
हाँ जी,
प्रिंसिपल कम इंक्वायरी ऑफिसर
ये रिक्वेस्ट है जी, ओनली ये मैंने इसमें जो प्रीलिमिनरी इंक्वायरी रिपोर्ट अलोंग विद स्टेटमेंट्स ऑफ द विटनेसेस ये डिनाई कर दिया उन्होंने।
डिपार्टमेंटल इंक्वायरी में प्रिंसिपल का क्या रोल?
मैं वही बताने लगा जी कि ही इज एक्टिंग एज अ PIO कम प्रिंसिपल एंड IO कम प्रिंसिपल।
You see, principal के principal will be having information को what?
ये IO भी है ना जी।
Don't जलेबी नहीं बनानी, मैं दुखी हो चुका हूँ 4 बज चुके हैं।
नहीं,
I'm asking you a very straight question.
हाँ जी बिल्कुल।
Assuming a principal is a PIO,
जी,
वो क्या information देगा आपको?
ने मांगी नहीं जी information, तो मैंने मांगी।
Please answer. Listen. He will give you information relatable to that particular school. अगर आप उस स्कूल से इंफॉर्मेशन मांगे कि फलाना बच्चा है, उसका मेरे को रिकॉर्ड से बताओ कब भर्ती हुआ था, कब उसने स्कूल छोड़ा
जी,
कि फलानी टीचर यहाँ पे कब से कब तक उसने पढ़ाया। प्रिंसिपल आपको अगर वो इंक्वायरी ऑफिसर है तो वो ये इंफॉर्मेशन कैसे दे सकता था? फॉर दिस पर्टिकुलर पर्पस, हाउ अकॉर्डिंग टू यू ही वाज
मैंने I have not sought any information under this application lordship।
ठीक हो गया, आपने नहीं मांगी?
मैंने नहीं मांगी।
फिर RTI बीच में कहां से आ गया?
यही मैं लगा जी बताना। अब वो बोल रहा ये इसमें इन्होंने डिनाई कर दिया।
ठीक हो गया।
अब देखें जी आगे P2 द रिपोर्ट, थर्ड लाइन जी, द रिपोर्ट ऑफ IO इज सब्जेक्ट टू रूल 14 गवर्नमेंट ऑफ इंडिया ऑर्डर 22/6। P2 जी इन्हीं की पिटीशन में लगा। द रिपोर्ट ऑफ IO प्रिलिमिनरी इंक्वायरी इज सब्जेक्ट टू,
ठीक हो गया,
गवर्नमेंट ऑफ इंडिया।
ये किस
22 ये इन्होंने दी।
किसने?
डायरेक्टर हायर एजुकेशन में।
डायरेक्टर हायर एजुकेशन प्रिंसिपल था?
नहीं जी, ये तो रिगार्डिंग टू द डिपार्टमेंटल इंक्वायरी, ये जो RR कौंडल।
सर प्लीज, ये जो लेटर का ऑथर कौन है?
ये तो जी डायरेक्टर हायर।
आगे चलो।
हाँ जी, नाउ मैंने इनसे जो इंफॉर्मेशन
किससे?
टू द PIO टू द IO सॉरी PIO दिस प्रिंस सरकाघाट कॉलेज।
कैसे, किस कैपेसिटी में? हाउ कैन ही बी अ PIO फॉर दिस इंफॉर्मेशन? सारे का सारा मेरे को समझ नहीं आता, क्या बंदे भरे हुए हैं बाई गॉड। वैसे ही बैठे हुए स्टेट इंफॉर्मेशन कमिश्नर में। I'm going to allow this petition with heavy cost. No one understands his job. एक केस नहीं होता पूरे दिन में। See, this is a very, this person has been dragged to the High Court for no fault of his. First of all, a flimsy application is filed before him under Right to Information Act.
My lord,
वो डर गया बेचारा कि पता नहीं RTI में क्या है। In good faith, he forwarded that application to some other authority, और उस authority ने therein where the entire issue starts.
कल ले लेंगे।
मैं आपको एक हफ्ते का टाइम दे देता हूँ दोनों पार्टी को रिप्लाई, बट आई हैव माय वेरी सीरियस डाउट।
ऑफलाइन लॉर्ड, ऑफलाइन
एक हफ्ते का टाइम दे रहा हूँ।
हाँ जी,
लेट देम फाइल देयर रिप्लाई।
हाँ जी, नो प्रॉब्लम।
I hope you have now understood.
बिल्कुल जी, बिल्कुल। I got.
See, the principal PI, I'm not denying it, but he will be a public information officer. Let us assume Mr. Tiwari is the PI of my court. Can you ask some information from him relatable to an inquiry being held by the High Court, simply because he might be associated with it?
Just explaining this example, then Mr. Tiwari is appointed as inquiry officer of some subordinate court employee. Now he's inquiry officer. Now in that inquiry, what he can supply is only
from him कि मेरे को वो दो।
कि वो थोड़ी मिल जाएंगे उससे।
ये ना बेस गलत हो गया हुआ है, and no one has appreciated and anticipated this.
ठीक है, मैं
And you say I do not blame your client. I do not even blame his client because they are novice as far as these issues are concerned. But I have reservations about the State Information Commission as to how the commission has dealt with it.
वो तो बहुत ही अलार्मिंग हुआ। मेरे को अभी बोला वो इन्फॉर्मेशन दो आप, नहीं और 5,000 जुर्माना भी तो मैं कहाँ दूंगा। I have to come to this court.
Jurisdictions day in and day out हम भी आपसे लड़ते रहते हैं कि how you have invoked the jurisdiction, how you have invoked the jurisdiction. One has to be slightly vigilant with regard to the.
ठीक है, I bow to my lord's observation. I'll.
The learned additional general has produced the relevant record from the office of the State Information Commissioner. The same stands produced by the court. On the request of respondents, the case is ordered to be listed on I'm listing it on 18th of June. I'm giving you enough time to file the replies. आप भी इनको Mr. Deputy AG tell them to engage a lawyer. Reply by the respondents in the meantime. Record from the Office of the State Information Commission. The record from State Information Commission as well as First Appellate Authority be also produced for the perusal of the court on the next date.
Please,
Interim to continue.
okay.
Shri Ajay Sharma. Ajay ji, ये क्या sir? Notice served 3, 4 and 6 sir.
Your Lordship, I am appearing for respondent 3 and 4.
Yeah.
Please, Your Lordship, now 6.
You are appearing for?
Please, Your Lordship. Or respondent number 6.
6. Okay, 3 and 4 के लिए Bhasin साहब 6 आपकी presence लगाओ. Reply within 4 weeks.
Please, Your Lordship. टाइम दीजिए इनको पहले
to the reply.
इनको थोड़ा टाइम पहले भी दिया हुआ जनाब दिया हुआ 1 अप्रैल से टाइम
किसी आप आई है एक बार
This evening today only.
पिछले वाले केस पे कौन सी डेट दी आपने?
15
इशू क्या है सर? बसेस का ये
हाँ जी
डेट दे देंगे. We'll see on the next date. If they do not file reply, then we cut it in. Mr. Arush.
Body title
पिछले वाला था ना उसमें भी यही डेट है.
उसमें भी डेट देना है